I mean, they will certainly come forward. I don't think they need a prodding.
It's a direction for a time-bound implementation.
The
Or a
RBI,
response
I'm so sorry.
to this honorable court in terms of what is the state.
What happens to
The RBI is already on the job. They're going to do that. We don't need a prodding for that purpose.
My lords, we are not looking at it as adversarial. This is just to ensure that the good work gets carried forward.
No, I wish you give a little time to RBI to do their job. They must do their job. They've gone for consultation, see that comments have come, and with the next IDC meeting, we'll take stock of it.
That's why they have to.
My lords, may I make a simpler suggestion, my lords? I have given a detailed submission. It may just be directed that IDC may consider all the suggestions or submissions by amicus and they may action it. Just a catch all, and I'll then leave it to IDC.
Consider all stakeholders with that.
My lords, as of today, my lords, whatever has been submitted today,
To whom will should direct?
IDC may consider the submissions or
The
suggestions.
departmental committee.
Yeah.
Departmental committee is directed to consider all the consolidated suggestions, or recommendations that have been made by the non-provider.
My lords.
Direction.
Post the matter after 4 weeks.
Around maybe in middle of September. So it's been a little more time. Around the third week of September. I mean, IDC has to do a lot of work.
First or second week of September.
It will be the third week of
22nd?
22nd September, I think. So what happens is after the IDC has a meeting, then it comes back to me and then I look,
What about 9th September,
We'll need more time.
no, we need a little more time.
10th September or
Next week.
Or-
No, I thought either 19th or 22nd.
15th September?
Very well. Because what happens is I just want to share my
19th or 20th.
19th, is it? Very well.
And it's a holiday.
19th.
19th is holiday,
19th is Saturday.
then 16th September.
Very well. Very well. Just one small.
Item 17 is tagged with them, you tag again.
In direction number 6, one small suggestion. Lordships, in direction number 6 at page 26 regarding committee to consult, etc. I said, and to suggest provision towards due compliance. The word suggest may kindly be added so that it makes sense.
So what date? 19th is at 16th. Okay. I'll be speaking to the applicant.
Thirty-one.
My lords,
Lordship, we are at serial number
Lordship, on
7.
item 31,
That's it, survey.
31 and 31.1. Yes, insofar as 31 is concerned, we have a illustrious tribunal before us. My lords may kindly confirm the tribunal. The questions of law involved in 31 have been answered in the constitutional bench judgment.
Yes.
Insofar as 31.1, there's a slight problem. My clause says there should be a panel of 3 arbitrators, but we have been appointed as 1 arbitrator. My lords may consider the sole arbitrator so appointed can continue as the presiding and the 2 parties can appoint the respective nominee arbitrators. The intention is that there'll be technical disputes.
But I am appearing for respondent in 31.1. I have no difficulty in this suggestion which my lord.
13.1.
31.1, my lords, the Honorable High Court has appointed one of the retired judges of this Honorable Court as the arbitrator. Let him act as a presiding arbitrator, and each party will nominate one arbitrator.
Item 31.1.
One.
Learn counsel for the party. have agreed, say during the course of hearing, learned counsel for the parties have been persuaded to agree that the sole arbitrator appointed by the High Court shall be the presiding arbitrator, and both the parties shall nominate their respective arbitrators, The needful shall be done within 2 weeks.
2 weeks.
Within 2 weeks, the 3-member arbitral tribunal shall thereafter proceed with the matter in accordance with law. It is clarified that we have not expressed any opinion on merits.
Only one thing, my lords, since we have already filed this statement of claim, let the arbitration proceed from the stage where it,
Yes, it's okay.
your lordship may say one line.
The stage it.
From the stage.
It has already.
The learned arbitral tribunal will proceed from the stage it has already reached.
I am so grateful.
Lord, item 31, as my learned friend said, my lord, is a panel of 3 retired honorable judges of this court. So, my lord, I think he's withdrawing his SLP or it can be dismissed.
My
My lord,
lords,
the
may
High Court
direct,
had appointed.
no, my laws may direct me to continue with the existing arbitrator. That should
The
Item
suffice.
31.
31.
Item 30.
The honorable tribunal
Learned
says.
counsel from the counsel for the party. Remove the fact that the learned arbitrator has already resumed proceeding.
No, they
My
have
lord, your
only
lordship,
been-
my lord, your lordship had requested them by an order of 2020 to not continue. But before that, the SOC had been filed. The panel had been constituted of 3 honorable judges.
it has been lying in abeyance.
Right, in view of the fact that the High Court has already appointed the learned arbitrators, we are not inclined to entertain the specially petition. Entertain this special petition, especially because of the reason that it is unnecessarily delaying the arbitration proceeding. So consequently, the special petition is dismissed. The parties may
Continue the arbitration from the stage
close the learned arbitrator for further.
for continuing the arbitration.
Lordship,
For continuance of the arbitration.
For continuing.
Lordship, in item 31, my laws may please record that my laws have not expressed any opinion. There'll be some disputes which will be taken.
However, the question of law raised in this case is kept open to be answered in appropriate question.
Please, Lordship. Deeply obliged.
Grateful.
Grateful.
But this matter is now coming up after almost a year. My lord, actually, this is not a matter where, my lord, the order is an issue. It is actually, my lords were looking at what is clogging the DRT and DRATs. And my lord, one of the issues which we had pointed out before the Honorable High Court was that there are about 1,21,000 cases pending before the DRT, out of which only about 1,500 cases cover 80% of the total amount which is locked. So almost 11 lakh crore rupees is fought only for about 1,500 cases. So if the DRT or the union can come up with a policy to only expedite these 1,500 cases, almost 80% of the money which is locked in DRT and DRT will. So, my lord, what had happened? I just want to apprise. My lord, a decision was taken that 3 or 4 courts in entire country will expeditiously only deal with these 100 crore cases in the entire country. My lord, thereafter, various high courts granted stay. So now neither those cases were decided by the DRT, nor, my lord, any matters were being taken up by the other courts. So even those 100 crore cases which ordinarily would have been decided got stuck because of those various pendency. My lord, this was one of the aspects which we had pointed out. Similarly, my lord, on the vacancies we had pointed out, and this honorable court had framed 20 questions which were given to the learned ASG who had appeared at that point of time on behalf of the union.
I'm still assisting, Your Lordship.
Oh, so sorry, I didn't see that. So 20 questions were framed by this honorable court for the union to answer, and an affidavit was filed on the steps being taken. Lord, my humble request is, my lord may consider, because it is an ongoing process. It will help the institution after all. My lords is already considering in the other tribunal issues, but this is more specific.
That issue is being, because it's comprehensively we are considering that issue in the matter of appointment of.
That is only one aspect, but DRT and DRATs are plagued with various other aspects also. For example, my lord, like under IBC, there is a board. Now board keeps on, if there is any hurdle, board keeps on coming up with statutory notifications to remove those hurdles. Well, there is no similar provision. So one of the suggestions given to the union, which this honorable court had permitted us, was to give suggestions of how to expedite and improve the processes in the tribunal. The hardship being faced by the banks, because this is, after all, public money. So, my lord, then the suggestion was that if similar board can be there, we need not approach the court for resolution. The board itself will look internally what are the ways to keep it efficient. My lord, then another suggestion apart from these two, there were other suggestions also having a panel of looking at the vacancies in the forthcoming year, e-filing, process of service on, because unlike in civil courts, usually in DRT and DRATs, in the essays and OAs, there are numerous respondents. So there are about 13, 15, 20 respondents. And each file is running into thousands of pages. Now, physically serving all the parties take itself a year or 2 years to serve.
My lords, may I assist? My lords, actually, we have been able to iron out a lot of the issues. My lords, union filed a petition at that stage because there was a mandamus from the High Court that you frame the rules and you do it in this manner. A lot of issues have been ironed out. The issue of 100 crore plus jurisdiction, my lords, notifications we issued, my lords, and it's placed on record. My colleague is right that they have been stayed by various High Courts. We have filed a transfer petition, which is pending before your lordships, my lords. So if your lordships may like to consider that 100 crore issue, that will sort out all other issues. To our mind, my lords, we have sorted out, we have found solutions. There will be more issues, we'll continue to find solutions together. But 100 crore issues is pending before your lordships in TP civil.
Can you file a latest affidavit cum status report?
Yes,
that
my lords.
How the working condition of DRT and DRTs have been improved?
Please, my lords. We will do that, my lords, lordship.
And we can also file a short submission of what we propose if my lords can consider while hearing it finally.
My lords
If
may
some
kindly
suggestions
also
are for
have
the-
this. My lords, one of the biggest issues is that the notifications have been stayed. Would your lordships kindly have the transfer petitions filed by us 636 of 2023 along with this matter, my lords? That will ease out a big chunk of the issues, my lords.
Only 32 is here, the TPs are not listed.
Yes, TPs are not listed. Their notice has been issued. They are being taken up separately. They've not come up for hearing for a long time, my lords. Lordship may kindly have the TPs. My colleague will give the complete number to the court master, my lords.
This matter is any date in this case?
No, my lords, it's 7th August, my lords. I think.
Tag TP civil number 636-645, 2023 along with this case based on so date. Union of India shall file, be directed to file a latest status report with respect to the working condition of DRT stroke DRT. The instrument may also do their suggestion.
Very
Based on
great.
so date.
So obliged. Or any date is being given?
Yes. Grateful.
Then who made it?
Obliged.
Item 33.
My lords, I'm being led by Mr. Guru Krishna Kumar in this matter. He was in court till about 4 o'clock, my lords. He's left for the day. May I request for next week, my lords?
Confirming next week.
Lordship may fix the date and may order that my item may not be deleted because my MA is from 24 and first day today it has come for hearing and again adjournment is being spoken. I am 33.5.
Your Lordship, fixing some particular date?
Note 34, the inquiry was ordered by District Judge Lucknow The inquiry report was circulated, but the inquiry report has clearly said Lucknow Development Authority was never the owner. The owners were Guptas. Guptas sold 2/3 of this land. They have taken compensation for 1/3. They are not claiming the remaining 2/3. And their records of the sub-registrar have been seen. There is no register number being maintained. There is no index. And when mutation was sanctioned, she's a lead widow. Twice over, they have paid me compensation. In 2015, they paid me compensation of about 11 lakh. Then Malad passed a direction that no, it has to be acquired in terms of 2013 Act. They passed some award not consistent with the Act and paid me 23 lakh again. But Malad again passed an order that no, it has to be in terms of 23 Act. Then they passed an award and they say now 11 crore is payable to me. It is only during contempt proceeding they came out that no, their sale deed seems to be not correct because that register number was not there at that point of time. Now, district judge has gone into all of this, given a detailed report saying this Lucknow Development Authority was never ever owner of this land. If at all, Guptas can have an objection. Guptas have taken 1/3 compensation, 2/3 belongs to this widow lady. So nothing survives.
What is about your title?
No, my title has been found to be in my favor by the district judge Lucknow now in a detailed report.
Well, the report records. My learned friend is partially right, Malad. We did nothing, Malad, for all the time when the proceedings were going on. Only in contempt we woke up. That's correct. The inquiry report clearly finds that the sale deed is said to be of 1972. Mutation sought 42 years later, 2014. The sale deed, Malad, purports to be of register number 1536. The inquiry finds that when the sub-registrar is called, he produces the registers having number 2101, 2102, etc., which are for the period around 1972 when this sale deed took place, allegedly took place. The 1536 register is of 1956, Malad, when the sale deeds of 1956 were taking place. The inquiry really goes on to say that we have not been able to prove our case. With greatest respect, the inquiry was to ascertain the truth. Of course, we don't have all the proof.
The point is that you have not been able to prove your title.
Yeah,
they never claimed to be owner.
What we are doubting here is that this mutation done 44 years later.
You are doubting.
I agree, Malad. We have not been able to.
You are not the owner. You are not claimed owner.
The inquiry finds even the area which is being mentioned is, Malad, completely contrary to the record.
Question is that you have acquired land.
Yes.
And you have taken possession of a particular parcel or piece of land. Right?
Not true.
You only pay compensation for that.
Yes.
You don't bother about anything. You have taken land from them. They are recorded as owner. Is there anyone else who has come forward to claiming title?
So, Malad, we have paid other co-owners. There is no dispute,
Yes.
Malad. Insofar as this person's title is concerned, we had a doubt because signatures are totally different, register is totally different, area is totally different, etc.
As you are concerned, had you been claiming ownership, then things would have been different.
My lord is right. My lord is right, Malad.
Someone else, nobody is coming forward and their co-owners have been paid compensation.
But they're getting a windfall from 11 or 15 lakhs to 11.5 crores, Malad.
Public money.
And public money of 11.5 crores. That was the
Gupta family. And that Gupta family has taken 1/3 compensation.
Land has been acquired. This is the value of the land. It may be 11 crore, it may be 11 lakh.
All the others got, Malad, on the lesser rate, my lord's judgment that this person has come, now give them under the new act. Acquisition of Malad's 19. Yes, of course.
Can't be allowed to argue.
I agree, Malad.
Otherwise,
Malad,
they have
may I-
paid
if your lordships will permit,
compensation twice
may I
over.
just file an affidavit concerning this, if your lordships permit, Malad, but I agree. We have been sleeping, Malad, for decades. But if your lordships permit, we'll file an affidavit regarding what this report says and doesn't say. And just show to your lordship what material we have, Malad, and we'll leave it at that. If your lordships permit, Malad. Yes.
Lord, if
Amount is deposited. As per your lordship direction, amount is deposited.
Lord, the report says I purchased it from my co-sharer Gupta family.
Wants to file an affidavit.
Let, as your lordship.
So the report, the fact-finding report from the land district judge has been received. One counsel for the
Lordship.
Lucknow Division to 36 and granted 1 week time to file their objections to the report.
Could be 2 weeks, Malad, you do these things. 2 weeks. 2 weeks.
As a last opportunity.
This is the first opportunity. We never start time.
There was an earlier direction.
Somebody else appeared and took time.
There was.
No, this report has only come on the last day. This was given to us on the last day. Never. Your Lordship may take it.
Yeah, Malad, sufficient dates have already been given to them.
No, not.
This
to file a
report was
report.
given last time.
Report was given only in the last date of year.
Their objection
But in a
posted
week
advance
back.
also there.
Grateful.
Obliged. Otherwise, we have a weak case. We've been sleeping for 4 decades. I agree, Malad. I agree. But it's public money. We'll put it here, Malad, and we'll leave it to your Lord.
It's already secured.
Yes, before.
We also
Bank
want to-
account,
Yes.
fixed deposit.
Yes, yes.
We also
So
want
let
to
them
satisfy
go.
Yes,
also.
absolutely. Absolutely. I agree.
Doubt was created, we thought we
Let
must.
them go through the
verify.
paces.
Absolutely.
Still, that problem is of register my lots of 70s and 50s. That's our whole difficulty.
That is
Obliged.
suspicious.
Item 35 is an appointment of arbitrator.
My lords,
No.
before he starts, the respondent number 1 has passed away, my lords, so he might have to.
Well, by section 40 of the Arbitration Act, once an arbitrator is appointed, his mandate continues despite death, my lords. So the High Court had appointed the arbitrator. If your lordships continue with him, then we can bring the legal heirs on record in the arbitration.
Only dispute between you both was that he was found to be a USA citizen.
The petitioner, my lords.
Therefore, the High Court passed that order, so therefore present arbitration has been filed.
Please, my lords.
But there is already an arbitrator appointed.
There is
by
an
the High Court.
arbitrator appointed by the High Court at page 116, your lordships may see.
Raise all the objections before the arbitrator.
My lords, I was only engaged by the respondent number 1. I have already informed the,
Arbitration it has to be done by us.
The objection as such, you can.
my lords, I do actually, because the arbitration agreement itself is disputed, which is why if he has to bring the LRs on record, then he will have to.
That
My
we
lords,
can issue to-
My lords, the counter had been filed on behalf of the respondent the signatures were disputed. There's an FSL report also. But now if he's no more, my lords, he will have
Filed a
to.
section 16, my lords, it is pending.
Has passed away, let the legal heirs be brought on report. Land counsel for the respondents shall also have instruction as to whether the learned arbitrator appointed by the High Court can be allowed to continue under the orders of this meeting.
Yes.
Just see, Mr. Okay, Mr. Sibal, tomorrow?
Yes, Malad. Please give us some time, Malad, so that we can finish it. I understand, Malad. If tomorrow, if your lordship can take it up, Malad,
On priority, my lord.
whenever it's,
We are not aware about the cause list tomorrow, but the miscellaneous matter will have to first.
no, I don't dispute, Malad. Just give us some time tomorrow. That's all, Malad. If your lordship fixes it at 2, Malad, then
In
we'll,
any case, not before lunch, you come to.
all right, so 2 o'clock, Malad, we'll be here, Malad. Your lordship may take it up. That's all, if it's possible. Otherwise, Malad, we always seem to be running out of luck.
With my lord's permission, may I please mention a matter, my lords? My lords, this matter was filed on Wednesday. However, the registry raised some objections. We have made our best efforts to clear it out. We just wanted to be listed urgently tomorrow, my lords. There's demolition notice has come, and tomorrow, 11 o'clock, I'm told that they'll come. If it could be taken up tomorrow. We have received the demolition notice today at 3:30, my lords.
3:30.
Today at 3:30, we have received.
No, but you didn't go to High Court.
We have already filed a petition here, my lords.
SLP.
SLP here, and it is pending, it's pending in the registry, my
High
lord.
Court dismissed the matter.
Yes.
Yes, ma'am.
Special by the High Court, you have received a demolition notice.
Yes, ma'am. Yes.
Dismissed. When was the order?
30th of June, my lords.
30th of June, the order was passed. They were waiting for this.
You clear the defects.
I have done that, my lords. If only my lords could direct.
लगा दो कुल Wednesday को जाके.
Your Honor,
So grateful, my lords.
Your Honor, I also got the diary number kindly listed for day after tomorrow. I got the diary number kindly listed. For
मैडम आपका तो लगेगी petition, आपकी कौन मना कर रहा है?
Sir,
We'll list
please,
your petition day after.
slip is there day after tomorrow.
Day after.
Janab, agar kuch, I can get something mentioning over there. Day after tomorrow, but how to tell them to the registry?
Your summons is for next week, no?
Highly.
Well, I mentioned, Your Lordship said, give a consolidated list, Mullahs, in one volume. We've done that. So,
Oh, very
Mullahs, it'll
good.
be easier for Your Lordship.
This will help you and us both.
We don't have to, Mullahs, move from one volume to another.
We'll take up tomorrow, maybe maybe maximum 2:30.
Maybe,
Well-
that's fine, as long as some time is given. It's
Your junior will come before lunch, we get up at 1 o'clock, we will let you know.
deeply,
So that
deeply,
you may not wait.
very well.
The number is 218108.
Your Lordship, may I mention Civil Appeal 283 of
Lordship, may I mention a matter? This is an application in a way my lords had passed an order and had asked me to dispose of whatever is available with me, my stock, by a particular date. I've not been able to dispose of the entire stock. I've filed an application seeking more time. Unfortunately, my application is not getting listed. I don't want to be in contempt. I just want this application to be listed to place before my lords. Whatever order my lords will pass, I will obviously absorb you. Much obliged.
With your Lordship's kind permission, Lords, I am mentioning a matter, Lords. I am seeking permission for numbering an I in Lords, A in Godavarman, Madam Lords. This pertains to an order your Lordship had passed on 20th February last year, Lords, with a direction to the Ministry of Environment to, Lords, do a calculation of NPV, Lords, within 3 months. Despite, Lords, numerous requests, Lords, they have not done it. It's been 18 months, they are sitting tight, Lords. I have filed an application, but since there's an order of your Lordships,
Segregation action. No matter, there are numerous applications filed in that case, and there is no head and tail, so we are now segregating those, we are trying to bunch the application.
there is a direction which your Lordship had passed that without your Lordship's permission, the applications were not getting numbered, Lords. I'm only seeking if my application may be numbered and Lords placed on any convenient date whenever, Lords. That main matter is listed today also.
Close the MICA.
We have already requested him to segregate the application on subject wise and then get them listed. Otherwise, all the applications are listed on Monday and it becomes impossible to deal with them. So you also give the details of your application to the amicus. Let us see in which group we will include and make a mention here.
So, Lords, even the application which have been freshly filed, Lords, mine application is a freshly filed, not.
Tell about that application to amicus,
I am
otherwise it
sorry.
will not be listed.
I am sorry.
With your Lordship's permission, Lordship, may I please mention a matter on behalf of the learned AG? Item 30 that's listed today, the digital arrest matter. The Lordship had fixed it for today, but there's a specially fixed matter in court 4 where the learned AG may be held up for the entire day. So we're requesting if it may please be taken up on another day.
My lords, on behalf of the learned amicus, I'd request that it be taken up as per the list.
It's already argued. Based upon that, we will issue direction. AG has requested us to issue some directions.
Lordship, there are certain additional submissions that the AG also wishes to.
The submission will give a date, but at least the pending directions can be issued today.
With my lord's kind
Your Lordship may.
With my lord's kind permission, may I mention a fresh matter? This pertains to the Jawahar Navodaya Vidyalaya 6th standard admission. We are in merit list only because we are in transition area. High Court says that you belong to urban category, so you cannot be considered from rural category. And therefore, we are here, my lords. One SLP is already allowed by Code 2. I just want a fresh listing because admission process are already over and academic session has begun.
Your Lordship.
Yes, my lords, I am requesting it for Friday.
We are listing all matters.
Your Lordship, may I mention Civil Appeal 283 of 2022? Your Lordship, the early hearing application was listed before this bench on 13 July, but the ROP has not been uploaded till now.
It has not been uploaded. Then that must be my mistake. Will upload it.
Please wait.
Because unless I will vet the order, it will never be uploaded. I might have taken time. So now your prayer is infructuous because we uploaded yesterday.
Lordship, I'm mentioning
Much obliged.
the fresh petition, this is a writ petition under 32 of, there is an issue with respect to the NEET exam. There are 6 students who are having alleged that what they had marked the answer in the OMR sheet originally and what the NTA is giving right now the OMR sheet to them, they have a difference, Lordship, because when the NTA has given the challenging period to challenge the OMR sheet with respect to its factual corrections along with the submission of the answer, at that point of time the OMR sheet was correct. But when after declaring the result,
We are not hearing on merit. Tell the urgency what it is.
urgency is that, Lordship, these are those students who are getting, these are those students who are getting more than 600 and 650 marks. Now they are
It was uploaded.
definitely, Lordship, the number of emails, even we had visited the NTA office, the officers has directly said that go to the Supreme Court, we don't bother about this.
Put in the objection when the OMR sheet was put in for the purposes of objection.
Yes, Lordship. Lordship, at that point of time, there is, Lordship, at that point of time, no OMR sheet was uploaded. This is a fault from the NTA side, Lordship.
Anyway, you give the details, we will list it.
Yes, Lordship. Obliged, Lordship. Lordship, it's an urgent matter, Lordship. It's in a day or two, because the counseling is also ready. It's only a 6 students prayer, Lordship. Obliged, Lordship.
Please, Lord, I'm just praying for the expedite of the hearing. Lord, this is the early hearing, Lord, 1989 notification. Kindly just consider.
You can wait for some time, right?
Lord, at least, Lord, because it's a 1989 Lord, notifications. And award is 92, Lord.
Appeal is of 2018.
Absolutely, Lord. 2018 is a leave was granted. It's a very short matter. I'm not going to take Lord, much time, Lord. If your Lordship fix the date, Lord, I'm going to argue, Lord. Any date, Lord.
We'll see after 6 months. We'll stop.
Please.
6
May I please, Lordship? In this matter, we are requesting for early hearing, Lordship, because the 70,000 square meter of land is under question, Lordship.
Once it was argued for some time.
Yes, Lordship. It was actually allowed to be listed last year, but it didn't come up on the turn. That's the major difficulty we are facing, Lordship.
So like, Swami could do it. Regular matter. पहले एक बार हुआ तो फिर रह जाता है.
September. Your Lordships.
19th August.
19th August.
September.
Grateful.
Some date in September, Your Lordship. September, some date.
September.
September. Third. Third is a Thursday. Did we get that? See?
What would that?
Oh.
Grateful, Lordship.
This matter, concerning benefits to judicial employees, 2010, 2015, earlier the urgency applications have been allowed, this matter was appearing in the regular list for a long time.
Date of those allowing applications.
No, any date, I'm not asking for any date sooner, but any date, may fix,
Item 4.
Matter is a divorce petition. Parties are separated since 14 years. Lordship, it's a divorce petition. Parties are separated since 14 years.
November.
It was last listed in November, Lordship. Item 4.
We are listing.
Sorry?
In November, we are listing, giving actual date.
So if it could be on an earlier date, if possible, Lordship.
We are giving November date, you are, what earlier?
Okay.
Great.
Lordship, in item 5, this is the CRP proceedings have been stayed from 2021. And
We have listed it in November.
November, whichever early date, because Lordship had already allowed an early hearing application and said July 23, but it was not, it didn't get listed.
That's why we are listing it in November, sir.
Please, Malaj.
Obliged.
For the appellant in this matter, very interesting question of law, but although I indicate, Malaj, we've not filed a rejoinder to the reply filed by CBI. But interesting question of law is, and there's no precedent to this effect, although there are other precedents of this court, that whether during pendency of the insolvency proceedings and the liquidation proceedings in respect of a company, and here it was pending since 2019, could there be a conviction order in respect of the company wherein a liquidator and a resolution professional is in charge and the company is undefended, company is nothing? Yes. So, Malad, if your Lordship will remember, Malad, now section there. Yes. Now, Malad, number 1 is Malad under section 14 of the Insolvency and Bankruptcy Code, when the company is in CRP, and this is supported by this court's judgment, proceedings against the company cannot continue. But Malaj, proceedings against the suspended board of directors and
CRP was not even approved.
yes, so CRP failed. CRP failed. Malaj, CRP failed. Then it went on to liquidation. Now, Malaj, would your Lordships kindly see section 32A2 of the code? Now, Malaj, what I am just only seeking protection of is, Malaj, there is a penalty that is imposed on the company. Now, kindly see 32A2 once.
Fine cannot be recovered.
Section 32A2, Malaj. And now, Malaj, because the proceedings under the code, now there are judgments of this code that your lordships have to distinguish between the acts done by the previous management and Malaj, someone who is now taking the assets over the company. Now please see 32A2 Malaj of the code, and would your lordship just see Malaj, one provision I just want to rely upon. Malaj, would your lordship just see Malaj, kindly sees 2A, no action, it starts with an non-sensitive clause, no action shall be taken against the property of the corporate debtor in relation to an offense prior to the commencement of the corporate insolvency resolution process of the corporate debtor, where such property is covered under a resolution plan approved under the adjudicating authority, which results in change in control or, well, there's an or now, sale of liquidation assets under the provisions of this. So, Malaj, my humble submission is today that when the liquidator under the provisions of the code, and this is Malaj for the benefit of all the creditors, the liquidator as an officer of the court, Malaj, is doing that. If Lordship sees or sale of the liquidation assets.
There is no resolution plan for you. Where
So
is the
now,
list of applicability of 30?
so 30, it's the second part. Kindly sees the second part of it.
How
Malaj,
the second come?
yes, Malaj, kindly sees or sale of liquidation assets. So it's applicable also during liquidation. No, Malaj, so I'll tell your Lordship what, Malaj. Today, Malaj, I will sell the assets. My learned friends in the reply have candidly Malaj, admitted one thing, that they are ultimately, Malaj, this penalty of 1 crore, this has to be paid as per the waterfall mechanism under section 53 of the code. But today, Malaj, ultimately, due to failure in not making the payment, the properties of the corporate debtor cannot be attached. In a similar situation, Malaj, the intention of the legislature, Malaj, I have already filed a compilation. Malaj, in similar circumstances under the PMLA, Malaj, the legislature in its wisdom has now made a provision vis-a-vis the IBC Act, because Malaj, your Lordship's judgment in Malaj, the Bhushan Steel Powers matter, your Lordships kept the question of law open to be decided, although allowed the property to be utilized in the CIRP and the liquidation of the company, but left the question open. After that judgment, Malaj, the legislature has given a provision that the liquidator of the company will have to give an undertaking before the courts that the assets of the company in liquidation under the provisions of the Insolvency and Bankruptcy Code will not be sold to a related party of any corporate debtor. It should not be a related party of the erstwhile promoters who have engaged in these kind of malpractices. But I filed my compilation. I have given that particular. Can I just hand it up? To your I just want to show now the legislature wisdom has also made provisions for this kind of cases where proceedings under either PMLA. Yes, would your lordship just come to page 445 of this compilation?
The exceptions engrafted in subsection 2 of 32 capital A, in fact, take care of it.
Correct.
That the sale should not be to a related
party.
of
I'm
a
so
prior
grateful.
creditor, prior management.
I'm so grateful.
And as the CBI has given the reply, it does not put an interdict on the conviction. Only with regard to the fine, the provisions of the IBC will apply.
Yeah. Now, I am
in the form of a due.
In form of a due under 53.
Fine is recoverable as land revenue. So if land revenue is recoverable under the liquidation section 94.
53.
Sorry, 53.
53.
It would.
As other debt. I bow down to your lordships. But and there's also.
Where is the legality of the conviction in question?
I'll tell your lordships this.
Nothing to do with conviction.
I'll tell your lordships this. Today, I am here before your lordships. I am as an officer of the court. It went undefended because I cannot defend the acts of the suspended board or the promoters of the company. During CIRP, because I had no role to play, because I was appointed by the National Company Law Tribunal. So, today the company went undefended since 2019. This conviction comes in 2025.
That is necessary. Don't, you know.
I will not.
Don't waste crocodile tears.
No, I'll not.
The court will appoint an amicus.
No. My only question today is these assets, which are now protected. I am only.
You are not the new promoter.
Yes.
You are buying the assets by way of sale of.
No, I am not. I am the liquidator. I am the liquidator.
That is where the catch is, my lord. I have my lord's permission. My lord, my cases read 32-2, my lord, with me. My lord, before that, hear me for 2 minutes.
Yes.
My lord, the original scheme is, if a company can be revived, you will extinguish the liability so that the company has a clean slate. The second part is, company is not revived. For reasons which are there in 33, there is an order of liquidation. My lord, here the rights are of the person, my lord, who acquires the property in the liquidation process. He alone has. Here, that has not even happened. The word sale here means an actual sale. Kindly have the provision with me for a minute. No such sale has taken place.
It's only by way of a company auction.
That's right. So that stage has not even come.
Acquisition is independent of a resolution plan of a going concern.
Exactly. And my lord, that is what they clarify, my lord. The word sale means no sale has taken place.
I just only need that.
Has taken place.
I just only need that protection from your lordships as a liquidator. I just need that they will file their claim for the penalty. It will be taken in accordance after the sale of the assets has taken place. But because of my failure not to pay the fine, because I cannot pay the fine right now because the company is in liquidation under IBC, it has to be dealt with as per the provisions of section 53. The properties or the assets should not be attached. And this from the sale as per 53, whatever their entitlement is, that will be paid. I am here before your lordships for that particular limited protection. I agree with your lordship's view, and in fact, now, if your lordship sees the judgments of this court, these judgments of this court clearly distinguishes from the act when a liquidator is in play, when a resolution professional is in charge of the company. Your lordship's court has always have taken a consistent view that your lordships have to draw a distinction between the acts committed by the previous management from Malad's post-CIRP situation, post-insolvency and a liquidation state. So I agree with my learned senior friend Malaj. The property is not being sold. We are selling because there was an ED attachment that is now being removed in light of the IBBI circular. This property will be sold, assets will be sold, from which the realization will take place. Malaj, now the crown debt concept has gone under IBC. As per 53, waterfall mechanism, whatever their entitlement will, they will get it. Well, my respectful submission is the property of the company may not be attached. That's the reason why I'm asking for a limited stay on the suspension of the sentence, that the fine, once it's dealt with under the provisions of...
Once the property is put up for auction.
Yes.
Sold.
Yes.
It won't be subject to the attachment, but prior to that, the attachment may prevail.
That's the whole.
Please understand the state of affairs. Here is assets in limbo, in your control of the company or the IBC tribunal through you. There is no sale. Till the sale, there is an attachment which is possible. As soon as there is a sale and a right accrues, it is not subject to the attachment.
No. So now, let's kindly see the explanation.
The word where such property is covered by a sale of liquidation under provisions of Chapter 3 to a person.
Now, Malaj, would your lordships kindly see the explanation now? The explanation that is given under this. For the purposes of this subsection, it is hereby clarified that an action against the property of the corporate debtor in relation to an offense shall include, that is inclusive.
Absolutely.
So,
My lord, read 2I of the explanation, everything will be clear.
Mr. Counsel, the explanation only clarifies the
substantial
provision. Where is the right or the immunity resting?
Yes.
Right or immunity is resting when a seller acquires rights in the corporate debtor.
Very well. Malaj,
Not in the corporate
very well, Malaj.
debtor, as the High Court has said.
That's why, Malaj, the only clarification, the limited clarification that we seek before your lordship is, if subject to the, I'm so good. But if, Malaj, we've been able to sell the property in liquidation, Malaj, as per 53, they will get as per 53.
The judgment is very clear. The judgment makes it evident that it's not in a resolution plan, and the right of a purchaser in a court auction of the liquidated assets have not accrued.
I'm so grateful.
If these are the two things not happening, the embargo of 32A2 does not set in.
Malaj, I'm so grateful. Malaj, what the learned court has, Malaj, I'll tell your lordships, has only gone on the principles of CRP, has ignored the second part of it. But your lordships are absolutely right. I bow down. That is
may have been better worded, but the clarity of the judgment.
Malaj, I bow down. Malaj, that is the limited protection that I require. Malaj, I will be able to sell it, pay them as per 53.
You are at liberty to sell
it. But this, before that, Malaj, there cannot be.
May continue up to the sale.
Yes.
Coterminous with a sale to a person who does not suffer the
up to the sale.
Qualifications under
29 capital.
or III.
I am so grateful. That's the limited protection that we get.
Up to the sale.
Up to the sale. Malaj, would your lordship just up to the sale, Malaj, kindly clarifies that, because otherwise I'll not be able to sell it without, if there is an attachment.
Covered by the law.
No, Malaj, but I'll not be able to, Malaj, sell it, Malaj, no prospective buyers will come, Malaj, if there is this thing, there is no clarification that is being provided. Malaj, the entire process will stand frustrated.
The government money is also.
Yes, Malaj, the government money is also important. The government stakeholders.
Explanation 2I makes it clear on acquisition.
Malaj, there are public financial institutions.
Protect third-party rights. That's the.
Malaj, I'll tell you, lordships, the problem is the public financial institutions whose money is involved in this IBC process. No buyer will come. This is pending since 2019. We've been able to remove Malaj because of this IBBI circular. Now, if there is this particular impediment that stays in, Malaj, crores and crores of public financial institutions' money, Malaj, which was given and which is now had to be Malaj recovered under this particular sale process, will be in jeopardy. Malaj, kindly, Malaj, lordships will kindly allow us, Malaj, to sell this, to make that observation.
Somebody will stop, then only you will come.
No injunction on the sale, sir.
But just a clarification, Malaj, because I'll tell you, lordships, they will enforce this order. They will enforce this order. And Malaj,
order, then no such clarification.
They will.
Thank you very much.
Right.
You are arguing very well.
Yes.
Item 7. 2 months more time, I think. For the reason mentioned, the latter date is 15th June 26 of the transcript. So much more time is granted to complete the transcript. 2 months from today.
The Lordship, in item 8, I'm requesting for a passover. I'm being led by Mr. Rohatgi.
We are broadcasters. So, my lord, tariff is fixed. Tariff is fixed, my lord. Fixation of tariff is not a legislative exercise. My lord, passing of a regulation which is delegated legislation is, my lord, a legislative exercise. Against the legislative exercise, we have to go to the High Court because TD side is not equipped, my lord, under law to decide, my lord, the regulation. That's the law. For the tariff order, my lord, they have to decide because they have to decide the tariffs. So, my lord, one thing happened, which is that, my lord, a tariff order and a regulation both were made simultaneously. One in exercise of legislative power, one in exercise of, my lord, administrative power. What did it do essentially? I'm giving an example. It amended, my lord, it provided a definition of subscriber. So, my lord, we supply to homes, we charge 50 rupees, 20 rupees a month. Yeah. We supply to hotels. So, suppose we give to Taj Hotel. So, Taj Hotel may have, my lord, 500 TVs. So, one question is, will they have 500 connections or will they have one connection? But even if they have 500 connections, they are equated in the definition, my lord, to a house which may have a one-bedroom house. We are saying that if you are charging, my lord, 50,000 rupees a room, then there should be a distinction between a commercial exploitation of a signal and, my lord, to a home which is a one-bedroom home. You can't have the same price. It's apples and oranges. That's our case. That's our case, my lord. So you have to have you can't have the same, my lord. So, my lord, against the regulation and the tariff, which came simultaneously, I moved the High Court in 2014. My lord, somebody went to TD side with the same kind of grievance. There is arbitrary, providing a non-distinction is arbitrary. So, my lord, TD side quashed it, that it is arbitrary. Against that, appeal is pending in this court. Thereafter, my lord, TRAI reworked after quashing next year, and, my lord, made it worse. Made it worse. That, my lord, is also now pending. That has been upheld, contrary to the first judgment. And those two civil appeals are pending in the Supreme Court, which will decide, my lord, essentially whether you should have a distinction or no distinction. That's, my lord, the administrative part. My writs are pending in the High Court 2014 and 15. Because I have changed the regulation. They were being deferred because these appeals are pending. They appeared one day before the bench. The bench took umbrage for no reason and said, look at your prayer. My lord, our prayer is to quash the tariff order and quash the regulation both. Though the tariff order was quashed, not quashed, it is Supreme Court, but regulation is there. The High Court has imposed cost on me. For what reason?
But Mr.
No, yeah.
The 2015 regulation
Yes.
was supervened by a 2017 regulation, which has been upheld by this court.
Lord, no, it's not the same. It's not the same.
That is the competence of the authority to pass those regulations was upheld by a bench of this court.
This has been left open, sir. If you
this question was left open.
In the 2017
was left open.
Except
I can show you that. But my lord, keep that aside for the time being. Look at the High Court's order. My lord, I have not understood the High Court's order. Kindly see the High Court's order.
We feel
We are not a fly-by-night operator.
Tariff order gets quashed by the TT-SAT.
In the first round.
In the first round, because your 2014 regulations mirror the first tariff order.
Absolutely right.
So that being the subject matter before this court,
Yeah.
the regulations really have now lost their relevance.
No, therefore, we not transfer the writ.
What is there to transfer?
2015.
My lord, it's an agreed position in the High Court of all parties that the issue is pending here, which is why a writ has not
So
been
you
heard.
argue the tariff order before us. Because the regulations will take care of themselves.
All at 10 minutes, the writ would be deferred, be pending for 10 years. For whatever it is worth. Look at the High Court's order. My lord, why the umbrage? See the umbrage.
As you rightly said, why are you challenging the regulations before the High Court? Because you are challenging on legislative competence and other things.
Yeah, also.
That issue has been decided against against the broadcasters in the 2017 regulation.
No,
They say that.
But the regulation is like a menu item. The nature of services in the regulation and the prices in the tariff order. They are intrinsically linked.
Levy is prescribed in the tariff.
Yes.
The classification.
The nature, exactly. So, my lord, they are interlinked and interconnected. One without the other is non-functional. So, therefore, my lord, a composite, comprehensive.
He filed a composite challenge, my lord, in the High Court. Somebody went straight to TD-SAT. TD-SAT is now here. Whether you hear the writ or don't hear the writ, I've asked for quashing. So what is wrong with that, my lord? Your lordship will see the order.
What is the impugned order before us today?
Have a look.
That is not the final disposal of
No, that
My lord, this shows what.
Your leadership.
Hold on. Kindly have a look at the order. Kindly have a look at the order. Your lordship will find page 1 bottom.
We are donating.
My lord, I will donate.
The
But,
issue.
my lord, to say that I should have asked for consequential. What is consequential? I have asked for quashing. I mean, what? Why?
You can report it back to the High Court.
My lord, with great respect, if I challenge, my lord, a regulation, right? If it is bad, it will be shut down. So what is consequential? I have not understood.
Let's see why the cost was imposed on you.
What amendment are you seeking in that writ?
I am not seeking. The judge is saying. My lord, I am not, with great respect, I have not understood, my lord, in my last 45 years of practice or for 50 years. I have challenged the law, right? Your lordship will strike it down, not strike it down. The judge is saying you should ask for consequential relief beyond striking down the law. Why? What? I can't tell the parliament to remake a law. The judge is now saying, my lord, that yes, you have challenged the regulation, but that is incomplete. You should do something else. Have a look at the order. I don't understand.
Mandamus asking you to amend. Please see the.
Why
letter.
cost? My lord, why cost?
Just see why cost. We are also asking.
It shows that the judge will now reject my petition on this ground. I am not going to amend anything, my lord, because I can't. But the mind of the court is clear that if you, unless you do something, I am going to knock you out, my lord. Have a look, my lord. Kindly just come back, my lord.
Impugned order.
That's the, 2 lakhs is not the problem.
Judge take his final decision. Then we will take the call.
My lord, just kindly, my lord, see page 2 for 1 second. Page 2. See para 4. Some oral assurance was given by counsel that corrective measures will be taken by amending. There's nothing to amend. I'll show you the prayers. Now, my lord, see para 7.
What is the
We-
point, Mr. Autaki, at some point of time, there is a, maybe a case of miscommunication.
Yeah.
But an impression has been created by your advocate that you want to amend it.
My lord, it's like the court saying you amend. The lawyer will say, okay, I'll do. But without realizing there's nothing to amend. Have a look at the prayer clause. My lord, can I show the prayer clause?
In that case, probably straightforward, somebody should have made a statement that though I sought an adjournment on the ground that I will amend.
Correct.
But I have gone through that, it doesn't require any amendment.
That's really the position, Lord. See page 127. If your lordship say a word against me, I will not utter a word. 127.
2 shows that there was a consequential brief. In view of Kusum ingots, they said it was not maintainable.
Kusum Ingot has nothing to do with this.
Cause of action.
It's a jurisdiction of Delhi High Court against central laws and all that.
But someone on your behalf probably accepted it that yes, there is a issue of consequential relief and therefore some amendment will be carried out. That's why please see para 3.
I've seen that. I've seen that.
Para 3,
But, my lord,
today when the matter is called out,
yes.
again it is brought to our notice. So that means earlier there is an history attached to it.
And please take a practical view, my lord. All these issues are common. They're all pending here.
My lord, can I just show one? Can I show only one thing, my lord? Kindly turn to 127 for 1 minute. 1 second, my lord. Page 127. It's not like an election petition. Declare his election to be void and put me back. My lord, it's not one of those. Turn to 127 for 1 second. Just my lord, see 127. See the prayers. See the prayers. This was a composite challenge, my lord. CA, strike down the tariff. CB, strike down the mirror regulation. CC, strike down the regulation. D, strike down the tariff. 2014 and after amendment 2000.
A and D is already gone.
Yeah, correct.
A and D is already gone.
I was only showing it for the purpose, my lord. What should I amend?
That is exactly, so there is a question of amendment.
There's no question of amendment. If something is gone, it's gone.
This repetition is therefore an infructuous proceeding.
Then
It's
what?
an infructuous proceeding. Because if the tariff order is reviewed by us and it is held that the order is valid.
Regulation will also be affected.
With regard to unreasonable
Right.
classification or the.
No, I understand.
Or the classifications that you claim.
Yes.
That we are entitled to charge higher in respect of commercial exploitation of our heat. It is for us to hold accordingly.
My lord, somebody may
Hold the TD set or set aside the TD.
But somebody may say, my lord, the regulation will be
Cannot, sir.
unaffected.
Regulations are only shell in which the tariff has been fixed.
So that's the backbone. Without the regulation and the interconnection, the tariff will be inconsequential. You need the left side first for the right side to happen.
Otherwise, Mr. Jain, the TD SAT would not have gone into these questions. These questions were before the TD SAT because the comprehensive prayer before the TD SAT was to assail the tariff
Order.
as well as regulations.
No, I'm sorry, my lord. There is no challenge to regulation before TD said because there is no jurisdiction. I didn't go to TD said, somebody else went.
Mr. Rohan, this issue, please see this.
Yes, I'm aware of this.
Then
I'm aware.
the coordinate bench has said that upheld the view of Kerala High Court that the power of TD SAT is to see whether the regulations are in consonance with the constitutional scheme and judicial review powers are there.
So even if you proceed that way, my lord, why should
It's a very, very technical, nice.
The matter is still pending in the High Court. I think it's better that you answer the main.
so kindly say, my lord, I don't want to amend.
So that you can make the statement there itself.
Then, you see, in light of para 4 and 5 of this impugned order.
Yes.
You please go move an application before the High Court.
Yes.
Saying that you don't require to amend your petition.
Yes, ma'am.
You don't want any amendment.
And the judge may decide it, not one way or the other, whatever.
And you come before us.
Then we'll come back.
Tariff
Your lordship may do that, record my statement. I'll withdraw this, my lord, and move the court.
They did give this oral assurance. They want to withdraw it. Of course, it's up to them.
Now with
They gave it on 2 dates.
They are
Withdraw here, not there.
Yes.
And collateral damage is more.
Why you yourself said, I will come back with an application.
Yes. Previous date also.
Para 4. That's your lawyer mentioned.
But, my lord, it's
Previous
just
date also.
stone. I mean,
It's a consensual order. My lord's query.
I'll withdraw this, my lord, and move an application. I'll withdraw this, move an application before the judge that I don't propose to amend. And then he may hear the.
My lord, may I answer my lord Justice Bakchi's query? That's at page 244. The repeal and saving provision, commercial subscriber definition was kept up. So it is a live issue, which is pending here.
We'll argue it.
Order is passed, you come before us.
Yes.
With liberty to move an
We
application
will.
before the High Court. To the effect that.
Lord, we have TPs also. That's why I'm making.
Amendment. To be made. Will be pending response.
I would think you had sent us back to try Dino.
You can't do that. You withdraw the TP also. We'll argue.
Pending application.
We'll withdraw the TP also, my lord. We'll go and argue everything.
With the liberty aforementioned. with liberty to move certain application along with consequences. Along with with liberty to move the aforesaid applications that may include prayer for amendment for modification of the order dated April 9, 2026, the specially petitioner disposed.
And the transfer petition also they will come. 8.1 is the TP. That's what we are withdrawing. TP.
Is also withdrawn?
Yes.
8.2 also goes.
Yes.
Great.
Great.
Much obliged. Grateful.
Term is over.
I appeal for the petition, my lords. I appeal for the petition, my lords. May I submit, my lords?
You are online?
Yes, my lords.
Yeah, where is the question of contempt, Mr. Contempt?
My lords, through an order dated 14/2/26, this
The
honorable
term is
court has
already over.
Term is over.
the term is over, lordship, but the elections have been deferred for the next year by one notification. The my lords, through the order dated 14/2/26, this honorable court had directed to the district magistrate of Sultanpur to take action against those 12 BDC members who had first given the affidavit in support of no confidence motion, and then later on
You concentrate on the next election, don't file this kind of petition. No case to initiate.
but lordship, but lordship, no action has been undertaken yet.
This is the DC.
That is.
Same order. Please notes.
For out of front hearing of the pending contempt proceedings. So we have no reason to doubt that such a case.
For 12.
Move the High Court early hearing. There is a liberty given.
Go file an application along with this order.
Please notes.
Item 13
Item 13.
was a fresh matter. I'm apologizing in advance. I'll have to seek an accommodation, Lords. I'm being led by a senior counsel. I'm seeking an accommodation, Lords. I'm being led by a senior counsel. He's had a personal difficulty in this morning, Lord. I tried to move an adjournment letter, but I got a little late. Lords, may I have it?
And an application, the adjournment slip.
Lords, I actually
circulate the letter.
Lords, I actually did try to circulate a letter, but I got informed about the emergency a little late. So I could only circulate it around 1, so it wasn't taken on record, Lords. I'm grateful.
Please, Lordship, this petition is raising a very serious lacuna in respect of a constitutional scheme, particularly in scheduled urban areas, Lordship. Lordship.
So you raise this issue.
Lordship, that is part of legislation.
Issue that you are raising
Lordship.
requires legislative intervention.
No, Lordship. In this petition, it is not there. In this petition, I am saying that since there is lacuna, there is vacuum, till then, because in 2001,
Exclusion or inclusion of an area
Lordship.
within a municipality requires an enactment of law, sir. You can't.
Lordship, that's correct.
do an
That's correct.
administrative order.
That's correct. In respect of Lordship, urban village
You are a
areas,
parliamentarian. Why can't you raise this issue in parliament itself?
Lordship, so far as the legislation concerned, request is
So
there.
dial the correct number, go to your back to the house, and we hope that you will indulge in some good constructive discussion there, debate, and raise this issue.
You can move a private member's bill. You are absolutely right.
That's
That if there is a upgradation
correct.
of a panchayat to a municipality,
Correct, Lordship.
the representative status as per schedule, the constitution, it gets downgraded.
Lordship.
So that requires a legislative intervention.
Lordship,
You can't do it. We can't do it.
2 point what I want to submit, Lordship. In 1996, the counterparts of the urban scheduled areas, rural scheduled area, act has been passed, everything is okay.
You are
And
right, act has been passed.
Lordship, and in 2001,
This is it.
Lordship,
So Mesa is there.
Lordship. In
Mesa is there. Mesa should come in.
In 2001, it is introduced but not passed.
It is just introduced.
It's still pending. Since 2001, it is still pending. It was introduced. So what I am praying, Lordship, since considering the backwardness of those areas.
In today's parliamentary democracy,
Lordship.
important legislations are waiting consideration of the parliamentarian.
That's correct, Lordship. That's correct. What I am praying before your Lordship here in this petition, till Parliament enact proper act, let there be certain guidelines, certain directions, so that at least elections can be conducted.
This is not an unoccupied field. It's already occupied by a bill.
Lordship,
Can we give directions which will in effect give legislative life
Lordship,
to a proposed bill?
once Lordship, this constitutional amendment came, the 1950 committee renders infructuous, but is still working because there is no enactment.
Pass it and declare it as a law.
No, Lordship,
In act of parliament.
that we can't do, Lordship.
That is what you are praying.
But till proper enactment, Lordship, at least there has to be election.
Fortunately for you, you have a very powerful platform.
Lordship.
You are a elected member of the parliament. It's not small thing. You are a public representative, and your voice is supposed to be heard. So you raise that voice at the right platform, and maybe that others will follow you. Because this is an issue.
The permission of this board, may I submit a submission? Certain
Yeah, you are.
urban schedule areas like Ranchi in Jharkhand, Jhabua and Madhya, they have the municipality. but they are under the schedule areas. So it is against the provision Article 243 ZC. So, and various fragmented petitions have been filed before Honorable High Court. High Court has, as the interim order, stayed that municipality, but still re-election has been convened. And
That's
this
it.
is not allowed under the law.
He has made a
Then-
presentation for the Ministry of Urban and Statement is presented.
Who is a member of Lok Sabha from Banswara, in bracket Rajasthan constituency, seeks the following directions, seeks the following relief through this petition, Article 32 of the Constitution, purportedly filed in public interest. Next one. We are updated that the relief in sum and substance, that in sum and substance, the relief sought in the resolution falls within the legislative domain and it cannot be given to this court to express any opinion in relation thereto. However, we also find from the report that the teacher has made a presentation to so-and-so ministry, which is 32 lying pending unattended. That being so, we dispose of this petition. We liberty to the petition to pursue that representation and let the competent authority in the ministry concerned consider the issues raised in this point.
No, in this matter, I'm only asking for notice and not for any interim thing, because in the meantime, the mangroves have been cut. Because the order, impugned order of the High Court is 23rd June, and thereafter it seems the National Highway Authority has already cut the mangroves in those 9 hectares. So I'm praying for notice, and I'll tell you also why that is very, very important here. The broad issue is that
Is there any specific order of compensatory afforestation?
Yes. There is an.
So the issue here is, just take the stick, yeah. Let me just delineate the DTAPA that is pending here before your lordships. Yes.
That on 28th of February 25,
Yes, my lord.
there was a report called for. Did anything happen on that?
That report has not yet been placed on record in that proceeding.
No, the report is placed on record.
In that matter.
In that matter, yes.
Otherwise, what we propose to do is the earlier proceedings pending.
Yes.
Where experts have been appointed and reports have been filed.
Yes.
So let us see the orders for compensatory afforestation and other requirements.
Yes.
Which MC that they.
No, but here in any case, that's why I said I only want notice, not stay, not any interim relief. But I'll tell your lordships why. Let me just delineate the issue, because just your lordships may just appreciate what is the issue. A composite a DT EPA clearance from the Dhanu Taluka Environment Protection Agency, composite clearance is taken for the port project, including the road and rail connectivity. Then a composite environment clearance and a composite CRZ, that is one clearance, is taken for the entire project including road and rail, in which in both of them, in before the DTEPA and before the CRZ and EC, categorical statements recorded, and the entire TOR is based on that there will be no forest clearance and there will be no destruction of mangroves. Now, on that basis, the permissions are given. The EC is given for the entire project, including road and rail connectivity, on basis of no mangroves. Now, I'm not on the necessity or anything. Now, when after getting all that, the NHAI, which is an agent of the Jawaharlal Nehru Port Authority, independently applies for a clearance for its road connectivity. And in that, they say, we now need forest clearance, we now need mangrove clearance, etc., etc. Will be 9 hectares of mangroves will be destroyed, etc. It is pointed out to the High Court that, look, there is only one EC. There's only one environment clearance and one CRZ clearance, which says no mangroves, no this, no that. They are relying on that. If it's an independent project, they would need their own, NHAI would need its own environment clearance and its own CRZ clearance, if it was an independent project. High Court says there's a letter 2 days before they file the petition to the High Court. They get a letter from a deputy conservator of forests of Maharashtra saying that this is an independent project, not from MOEF, not from the CRZ authorities. A deputy conservator of forest gives a letter. High Court says that letter shows that it's an independent project. If it's an independent project, then where is its environment clearance? Where is its CRZ? They are relying on an environment clearance and a CRZ which says no reduction, no removal of mangroves, no forest clearance, nothing. They gave 5, I'll show that, Your Lordship. They gave 5 alternative alignments in the TOR, and they said all 5 alignments involve no forest clearance and no forest diversion proposal and no mangroves. They gave the number of trees. They said 10,179 chiku, mango and wild trees will be cut, but no forest clearance because those are in plantations and so on. They number that, they measure each tree. High Court says after everything, when they went for land acquisition, they found in December 2025, they suddenly miraculously found mangroves, 9 hectares of mangroves. When they counted 10,179, not 10,000, not 20,000, 10,179 trees were counted and put in the EC. Actual number of trees. And they didn't, at that time, they didn't do any survey. So now what will happen is, this order of the High Court will be a template for the rail clearance. The next thing will be, because the two lines are running almost parallel as per the plan, the railway alignment.
All said and done, when such a huge port is constructed, well, it has to be connected with land.
No, it has to be connected. They gave 5 alignments with no forest clearance required and no mangrove clearance required. So I'm not on that.
If such a huge port is not connected through railways and through roads, how you?
No, of course, Milord, it must be connected.
National asset, how are you going to utilize it?
But they've got 5 alignments without that. Apart from that, Milord, there's one very important thing here. Let me just place this.
That we have to leave to the experts, and those who are working domain experts know very well better than us. What we must.
No, this is the High Court. Your Lordships knows that the High Court, under the High Court judgment of 2018, every mangrove clearance in Maharashtra has to go to the High Court, and now they make a petition to the High Court. High Court goes on the base. Now, in meantime, after the 2018 judgment of High Court, in 2019, a fresh CRZ came to be issued by the MOEF. In that CRZ, mangroves are in category 1A. And mangroves, even the buffer zone of mangroves, if a road is made, it has to be made on stilts. There's nothing to stop them making it on stilts.
That's why we are saying that our concern, your concern, our concern,
yes,
should be ensured that what is the way of compensatory afforestation? Is it only in papers or it is actually at the ground?
Yeah.
One.
That's why I'm saying issue notice here, because I want to place this before your Lordships, because they can't move the High Court with a completely false basis.
Also necessary from your end, because if you see the composite EC, you are absolutely right. Boat area does not require mangrove cutting. That is one of the conditions of
yes.
But with that same EC, Roman I, at page 401, says that the proponent shall obtain forest clearance for diversion of forest land as per Forest Conservation Act for the proposed road alignment. So there is.
No, not in the EC, there is no mangrove clearance, Lord. Let me show your lordship that what they.
We know the recommendation, TOR, on.
That's
the
right.
Recommendation of on which TOR was issued, there was a clear statement, no mangrove is to.
And in the DT EPA also.
The Taluka EPA also says it is about 100 meters from the buffer zone.
150 meters.
Right.
Yes.
However, these are all recommendatory clearances. Final clearance is the EC. And EC conditions permit two things. A, it puts an embargo or a clear condition that no mangrove clearance for port. However, for road, forest clearance permission has to be obtained, which in fact inerts a possibility of clearance of forest. Whether that forest, under the definition of forest, also 2018 Act include mangrove.
So please read.
And
Look,
on that basis, we can't say there is a violation of the EC on the face of it.
please read para 14 of the EC and Willards, if your lordship, what page is that?
393.
I'm not that page 393.
Right, we have seen that is the recommendation.
No, I'm sorry. That is in the EC itself.
True.
Please come to page 393, para 14.
Of the EC, I am talking of the conditions.
Yes, I'll come to the conditions, Willards.
In that, no mangroves will be cut was given as a condition.
Yes.
For EC clearance.
Now please see 393, diversion of forest land. The diversion of forest land is required in case of road and rail connectivity passed through the forest land, for which about 86.82 hectares of forest land needs to be diverted.
Yes.
However, as per OM dated so-and-so, the project proponent has presented 5 alternative alignments and justified that it is technically feasible to execute the project along an alternate alignment in which diversion of forest land is not required. The road will be developed by Morth NHI as per the Gati Shakti initiative of government as a greenfield highway, and land acquisition will be as per NHI Act for highways, and user fee will be collected by NHI. Accordingly, road and rail connectivity is being proposed through alternate alignment not passing through forest land. Now come to 402. Now please see 402, my lords.
Mr. Singh, before you come to 402,
Yes.
come to 401, Roman I.
Yes, 401 Roman I.
What they are
Proponent shall obtain forest clearance for diversion of forest land as per Forest Conservation Act for the proposed road alignment if the proposed road alignment is to pass through forest area. But they gave 5 alignments which are not to pass through.
What we are saying is.
What is the necessity for the High Court?
For the EC is not on the face of it breached if they choose an alignment which goes through forest land.
So
You are now indicating is 402 Roman
24.
Roman 24.
Yes.
The word is due to port construction.
That's right, but the entire project is known as the port project. Please.
The High Court makes a distinction at paragraph 22 of the judgment that yes, for the port construction, no mangrove was to be removed.
I'm sorry, that is.
For road construction, there was a permission for removal of forest, which includes mangrove, and because there is compensatory forestation and MCZA has given the permission, we are endorsing it.
Look, I'm sorry. Please see the CRZ of 2019. See that for a moment. Now, they were told that there is no 1A. No part of this project is in 1A, including the road. Now, mangroves come in 1A. Now, please see what is 1A. How does the CRZ operate for 1A?
Contentions before us, the MCZA clearance is in violation of CRZ 2019.
2019, absolutely. But my
contention was never raised before the High Court.
No, I'm sorry. My contention is let us not put too fine a point on it. Yeah, these points are all raised, but apart from that, let me just point this out. Please see that if assurances are given on oath in writing that this is one project, the port project consists of the road and rail connectivity. Just see that for a moment, right from day one. If your lordship kindly sees If your lordship sees the terms of reference first. The EIA report. Let's come to the EIA report for a moment, Lutz. That is at 255. Connectivity aspect, rail and road connectivity. Do your lordships have that? For any port project, the road and rail connectivity are absolutely essential for the cargo as well as for the vehicular movement. Therefore, the road and rail connectivity discussed in this report are not separate, and it is an integral part of the Vadhavan port project. Then, about 5 lines down, the new port, including the road and rail infrastructure, act as a catalyst for regional development opportunities for the local so-and-so. Then, at 326, biological impact potential of road and rail alignment. Impacted trees are 10,179 chiku trees, palm and other wild trees. This is for the road and rail. And then they say, that page 331, HTL, LTL demarcation and CRZ mapping. 331, your lordships have that? 7.6. And please come to the foot of that at 7.6 at 332. The proposed road and rail alignment for the port connectivity lies in CRZ 1B, CRZ 3, 200 meters to 500 meters, CRZ 3, no development zone, and outside CRZ areas as per approved CZMP. So the CZMP is based that there is no part of it in CRZ 1A. Mangroves are in CRZ 1A. This application by NHAI, which is only an agent. JNPA did not go to the government. The agent goes to the government. The agent has played a fraud ultimately. I am saying that notice must be issued for this. And this same template now will be followed for the railways. We are not against development. We are saying that ultimately they can't mislead the authorities, mislead the courts.
The High Court order itself notes that 208 mangrove trees were cut on an area of 9.2 hectares. As compensatory plantation, we are planting 1,33,000 trees over 30 hectares.
We would like to see that which is the area where is the land where you are doing it.
The High Court notes all that, my lord. Notice is not required. And secondly, my lord, the petitioner here, he's filed an application for permission to file. He was not a party in the High Court. In fact, this petitioner's SLP.
I was heard. My appearance, Ms. Minaz Kakalia's appearance is recorded.
I only said
Honorable High Court.
I only said he was not a party. And this petitioner's SLP is pending, in which my lords have already sought the report. Every ancillary order need not be entertained, my lord. Very reasoned order, and we've already paid 4 crores.
They don't even make the project proponent. JNPA is not made a party. I've taken out an IA to make them a party. When they apply to the High Court, they don't make JNPA a party in the petition.
I'll request
of proportionality. If you have 5 alignments available to you which don't affect forests, which don't affect, why do you choose one?
That 5 alignment, alternate alignment, that is now history. That is completely irrelevant issue now. The only issue that survives and limited issue we want to examine is the compensatory afforestation part and that expert report on environmental damage.
Yes.
And then what should be the correctional measures for that?
Yes.
If at all it is there.
There are 2 aspects why we are requesting that notice be issued. One is that this High Court judgment, I respectfully submit, proceeds on a letter. Now, your lordship, my Lord, the Honorable Chief Justice had occasion about 1.5 years or 2 years ago in the Isha Foundation case. Same thing. Letters were procured and on that basis, not the clearance was given. Your lordship said we are not interfering, but we make it clear it's only on the facts of this case we are not interfering since everything has been done and things have been in place, the buildings have been there for 20 years and so on. Subsequently, those letters and all were struck down by my Lord Justice Gawai's bench. So here again, a letter taken 2 days before filing a petition from a deputy conservator and High Court relies entirely on that to say it's a separate project. But if it's a separate project, it requires its own EC. It requires its own CRZ. That this aspect must be decided, because tomorrow we'll have the problem with the railways. And this will apply as a template in all other matters. And look, permission may be given.
In terms of the findings written by the High Court, as also to obtain the expert's opinion, expert's report with respect to the environmental damage effect from a returnable on so and so date, only for the two limited purposes we are.
One is regarding compensatory afforestation, and the second
The
one,
other is environmental damage expert report.
we'll file both.
SLP, tag with SLP serial number 24774/2024. List both the cases on so and so date. Then say, accept.
No, the one indulgence.
Accept notice on behalf of so and so.
नाम बताना.
May Vikrama Thanvi.
You are for NHI?
Yes.
Accept notice on behalf of NHI. Counter affidavit can be filed. Respect to both the issues mentioned.
No, I also have an IA to implead JNPA, because they were actually a necessary party before the High Court, but they were not impleaded by them.
Not unnecessarily expand the scope, we'll see. Permission grant.
Please, Your Lordship, please.
With great respect, you have to separate the wood from the trees. Let me tell you not similar two facts. Page 24. Yes. So, Lord, I am a company. In the year 2007, I took a loan from IDBI. In 2007. I returned it in 2008. That's one chapter. I am not a defaulter. I am not a debtor. So, my Lord, when I took the loan, a part of the loan was given by me to a group company. It has been shown in the balance sheet as an advance of a loan to a, my Lord, group company. So, my Lord, I have not cheated anybody. Nobody has been defaulter, etc., etc. An inspection takes place, my Lord, by the ROC in the year 2012. 2012. So they say, well, you have shown it as an advance. It should actually be shown as an intercorporate loan. All right, that's a matter of righting wrong. But it's not a case, my Lord, that I have diverted money here and there. Now, my Lord, in the year 2019, my Lord, a prosecution is launched against the company under 628 of the Old Companies Act. My Lord, so I have two questions, my Lord, to raise. Firstly, my Lord, no offense is made out under 628. Secondly, my Lord, there is a complete bar, my Lord, under 468 of the CRPC of limitation. Have a look at 628 first, my Lord. It's a very strange case, my Lord. Turn to page 20, page 20. My Lord, sir.
Yeah.
Just, my Lord, Justice Bakchi and Justice Mohan. My Lord, page 20. First, I will read 628 at the foot, my Lord. If in any return, report or certificate or balance sheet, my case is a balance sheet, prospectus or so and so, any person makes a statement which is false in any material particular, knowing it to be false, or omits, there is no case of omission, he shall be punishable for 2 years. So if I make a knowingly false statement, my lord. Suppose I file an affidavit, my lord, that I am not present in the Supreme Court today, I am present in Bombay. It's a false statement to my knowledge. If I make a false statement to my own knowledge, then I can be prosecuted. But, my lord, what happened was, your lordship may now turn to page 45.
2012 complaint.
2000, turn to 45.
Part of the report of 12.
This is, my lord, an inspection report of 2012. I am taking it as it is because I am conscious I am not adding or subtracting, my lord, for purposes of quashing. Turn to item 12, Roman 1. Page 45.
Page 45.
Yes, it's a part of the inspection report. Please take it as it stands. Though I have something to say, but I will not oppose it. In view of the above, it appears that the nature of payment of 20 crores to the other company is actually an intercorporate deposit, and advances given without interest are not investment. Accordingly, the board minutes do not contain a fair and correct summary and is in violation of 193(2). I have shown it, my lord, as an advance to a group company. Somebody says it's not an advance, it can be treated as investment or whatever. That's a matter of how you, my lord, perceive. But that's not a matter of falsity. I'll show you the actual balance sheet. Give me the balance sheet. You can't be prosecuted for this, man. It is my perception.
The finding is, Mr. Oggi, that this, at that time, it was a huge amount. It was not a small amount. You are investing it in the companies owned by a chief minister, and prima facie
That's
finding that all was done for quid pro quo.
Agreed. But that, my lord, is the CBI investigation, CBI charge sheet. It's not a matter of 628. My lord, 628 is the point. We will be sorry.
It's an arguable point in the trial. May not be a case for a
But there is no fact involved. The High Court says mixed question of fact and law. This is this is, my lord, I am accepting this statement. I have shown it in the balance sheet. Have a look, my lord. Give a copy. Please have a look at the balance sheet.
Maybe
How is it false?
It's a valid defense for you, but it will be a matter of fact only.
My lord, that's the first question. I've shown it. Second, my lord, in 2012, you are aware? Limitation is 3 years. Have a look at, my lord, come back to page 20. Now come back to 20. How can it go on, my lord, like this? Page 20.
That, Mr. Wadgi, was answered by the High Court.
High Court says it's a mixed question.
No. The reason is 2012, explanation was called for, and
I gave the explanation.
clarity was obtained when the supplementary inspection report.
Not with great, I'll show you.
Therefore, the knowledge is being.
No, I'll show you. Have a look at the explanation called for. See the explanation called for. It was called for at the same time. Turn to page, my lord, 119. 119.
Eventually, you might succeed even on this ground, but this is not that which can be accepted as threshold.
But, my lord, what about limitation? It's 3 years from the date of first knowledge.
No, that is Sarah Matthew. If you check Sarah Matthew, there is a 5 judges bench of this honorable court which says how a limitation can be construed for taking cognizance. It's not from the date the magistrate.
I'm showing you 468, my lord.
From the date of, you have to read it with 473. You can't read only.
No, 469. My lord, turn to page 20.
Not D was 473.
Just turn to
It's
page 20.
covered.
My lord, turn to page 20 for a second.
Yes.
I'll come back to, my lord, the explanation. Come to 20.
Where you are relying 468.
468. Now, my lord, kindly have a look. It's very important, my lord. It's very, very important to see 468. 468 says, my lord, except as provided no court, it's imperative. No court, it's a prohibition, shall take cognizance after the expiry of limitation and the period of limitation, my lord, C, 2C. 3 years, if the offence is punishable for a term exceeding 1 year but not exceeding 3. In my case, my lord, it is 3 years. Now,
469.
Now, my lord, 469 is not quoted. Now, give a copy. Now, see 469. Limitation starts from the date of first knowledge.
There cannot be any deviation from this clause C, 468 to C.
Yes, my lord.
The only question that will be determined based on evidence is that this year will be counted from which day?
So it's 469. I am very grateful for the Chief Justice question. Now, my lord, see 469, middle of the sheet, my lord.
No dispute over that.
469. The period of limitation in relation to an offender commence either below the date of offense, which is 2008, or where the commission is not known to the person the first day on which it comes to your knowledge. So what is the first day? 2012.
The real chart, actually the complaint is in 2018. When the
2018 is not the first date of knowledge, my lord. It's a supplementary report saying the same thing. I show you that.
information provided by you.
Milord, no, Milord, with respect, you can't extend limitation by periodic inspections, Milord. The law is the date of first knowledge. First knowledge limitation runs, it will end in 3 years. Merely because you have a second report which is identical after 5 years, then 10 years, then 20 years, it is elementary, Milord. That can't extend limitation.
In the 2012, definitely it was not known that there is an offense, element of offense. According to them, it came to their knowledge
Milord,
only in 2000.
how can that?
If it is 18, then 469(1)(b) will be attracted. And therefore, it will be one of the issue before the trial court, whether it is 469(1)(a) or 469(1)(b).
And BC 473 also.
In
2013. That's what Sarah Matthews says. You cannot read 468 without reading 473.
Correct.
Yes.
Only one more thing now.
That's a discretion
One more thing.
that they have applied.
Just see one more thing, Milord.
Yes.
Turn to 127. 127.
127.
127.
Annexure P5.
This Milord report was placed before the CBI court in the year 2013-14 at 127 at 128 paragraph 4. It is further submitted that one document, letter of ROC dated 21/8/13 along with the inspection report which I have shown to your lordship, which was collected during investigation, could not be filed with the charge sheet. Same is being filed. This is dated below 2014. Even then it is barred. So you knew in 12, 13, 14. What more is required?
No change is made by 18 report.
By Milord, your lordship may see the report of 2018. There is no change. It's the same thing. I show you that report also.
The comparison, just see.
Now I show you, Milord, something important. Kindly, Milord, have a look at this.
This is known to them as a. So
Milord, the words of 2018 and the words of 2012 are identical. Kindly, Milord, have a look at this.
The second report is sought to overcome the time of limitation.
The second report of 18 is verbatim. Verbatim, and it is meant only, Milord, to provide an extension of limitation. It is verbatim. My Lord may see, Milord, this chart I am handing over. Kindly have a look at this chart. Milord, your Lordship will see. I will read line by line. First 3 lines I will read on the left column of 2012. 3(1)(b) of the inspection report of 2012. Inspection revealed that the amount of 20 crores was paid and the same was encashed by the company on the same day as evident from so-and-so. Payments were made from IDBI loan proceeds of so-and-so, immediately so-and-so. Now see below the right side, 2018. Inspection revealed it's identical. See 2019, identical. This can't be not extend limitation. This is not a case of evergreening, that you evergreen and go on without with limitation.
Supplementary is called only to overcome limitation.
These are supplementary reports only without to provide.
Mr. Odgi, this ultimately the offense for which cognizance has been taken, that pertains to Messrs Pioneer Power Limited. The 2014 report which you are referring to.
2012. That document, yes.
127 which you are referring to.
Yes.
That pertains to Penna Cements and its group company.
It's the same company. It's the same company.
It's not Penna Cements.
It's a change of name. The same company. So, my lord, there is one holding company, there is one group company, and then there is prosecution. It's exactly, that's why I showed you, my lord, this chart which I'm giving you word by word same. How can that be a difference then? And I'll be prosecuted in the CBI court. I can understand. I can't be prosecuted for 628, my lord. 628, I am shown it as an advance. I have shown it as an advance.
Take all this please in the trial court letter of proceedings.
Lord.
And that should be open to be decided.
May I make one submission, Lord? Let the trial judge look at the issue of limitation first. I don't need any evidence. Kindly consider that.
Or the petitioner shall be at liberty to raise all the contentions before the trial court, and the same shall be considered in accordance with law. Yes?
Blind.
That's it.
These people are not interested.
Digital. Today the matters are there.
Yes, my lord, may we tag with the item 30, my lord. Much obliged.
Obliged, Lordship.
The challenge is to the circular, clearly illegal circular, my lord, contrary to the statutory provision. How can such circular be issued?
It's been already stated by the.
My lord, the committee, high power committee has said don't rely, but now my lord must stay this. Clearly contrary on all counts, on all principles of law, this should be stayed, my lord. Quashed. Unfortunately, we are council of senior lawyers and advocates passing such kind of resolution, my lord. Clearly unfortunate.
Has already stated this resolution.
So my lord, my request is not the high power committee has only told the returning officers not to rely. Lord, deeply obliged.
May I please?
May
My lords, your lordship's order of 27/7/26. My lords, your lordship had issued notice, stayed the FIR, but directed that the transfer should go on. This is coming on 10th. Lordship may pass the same order and tag it, my lords. In fact, I was not even a party. The others were at least.
Yes, sir.
Very good. Very good. Deeply obliged.
But here it's a neat question of law. Your lordships, we did not grant stay. So arbitration, I'm sorry.
Requesting for a Passover, Lordships. Item 18.
Then if your lordships can have it on some other day. The question is this. This is, I'm not addressing on merits since the other side is not there. I'm just analyzing, I'm pointing out the question. My lord, this is an arbitration under a state act. The state act provides for remedy of arbitration. The question is, while one of the parties go under the General Arbitration Act 1996, seeking extension of time, can the High Court, which is not having the power of 11, substitute the arbitrator? That is the question of. Your lordships did not grant stay, therefore the substituted arbitrator panel is going on. So there would not be any difficulty on that. But the question is a recurring question, needs your lordship's examination.
No, I'm here. I have to say 2 or 3 things.
No, this will have to be heard, my lord. if your lordships can.
I submit that this should not be heard, at least in this case. The facts will not be shown. Your lordship can leave the question of law open. The reason is this. My lord, my arbitration started in 2021.
He will be on fact.
Before, my lord, a government nominee appointed by them under a state act which is akin to NHAI. So he carried on, my lord. Then, my lord, after reserving, he changed. A second person is appointed. My lord, he reserves, he is changed. Then a third man is appointed. The third man wrote a letter, I have too much burden of my post, government post, I can't do this. So after this rotating, my lord, thing went on, my lord, for 5 years. I moved, my lord, the High Court under 29A, that please substitute now, because I am entitled to compensation for my land, which has been taken away. So, my lord, the High Court then sent it to the District Court because of lack of territorial jurisdiction. And the District Court has appointed a High Court judge. This is, my lord, the facts of this case.
Lord, I am not.
Whether it applies or doesn't apply, my lord, is a different.
I am not, my
case
lord,
of
let's raise
nature.
my voice also. Lord, I am not urging, my lord, your lordships to substitute and have some other arbitrator. I am only saying, my lord, the question is a recurring question.
Decided
That
some
may be
other,
decided.
but these are not the facts for a 136 period against my client.
What did he say? Because on 18th May,
Yes.
we made it clear that we already argued.
It's at the final stages.
It is at a final. We are not
Final
disturbing
arguments
them.
are going on before the judge.
My lord, nobody is. I am not praying that may be disturbed.
Why do it in this case then?
Question of law open.
Lord, he has to argue question of law someday.
He argued in another case, not this case.
Every time, my lord, it cannot be 5 prejudicial facts.
And it's not a case of prejudicial facts. This is the case of your own making.
It has to be someday you
By
have to argue.
what the clients have done. This is not a case for 136. For 5 years, I am going on like a bloody round.
Keep the question of law.
Not
open.
for 5 years like this. It's not fair.
We'll examine it.
Don't thumb the.
In the particular facts and circumstances.
It's only an emphasis. That's all.
Emphasis?
Don't wear a ring. It doesn't make a sound.
My lord, sometimes, my lord, I wish, my lord, question of law is also argued and we deal with.
Mr. Suresh,
But I am waiting for that case.
It will come next month. I have another case. I will send it to you in advance.
I am waiting for that case, that 5 facts, my
Send you,
lord, on
Lord, that's
prejudice
another case in the
cannot
office.
be. Keep the question of law open. But someday we will have to address on
I
law.
will send you next month, sir. It is coming here. Before this court only. I'll send you. I will send it in advance. Lord.
What is seemingly justified in appointing the arbitrator. That part we are informed that the arbitration proceedings are near completion, nearing completion, and documents are being. In light of that, we are not inclined to consider these special situations.
He left. Those who come from the High Court, my lord, there are so many things which are so surprising, my lord.
Please, your lordships.
Grateful.
We have kept the question of law.
Yes,
Grateful.
there is a letter.
Item 19, there is a letter.
There is a request, my lordship, from this. But only request, my lord, your lordships may adjourn it, I have no difficulty, but your lordships may fix give a fixed date only. That's the only request. Yes, much obliged. 20 and 20.1, there are two SLPs, my lord. One against the order passed by the High Court and one order passed by the appellate authority, my lord. Now, the question, facts are, my lord, the respondent is a manufacturer of drugs. Now, my lord, they are manufacturing drugs and two of them, Doc 1 Max and Ebronol syrups, my lord, they were exported to Uzbekistan, where 15 kids died.
My lord, with greatest respect, we have to examine the scope and ambit of Rule 85, subsection 3. whether a review would lie or not. Rule 85, sub-rule 3 of the Drugs and Cosmetics Rule 1945. To examine as to whether a review application can be entertained by the appellate authority or not.
My SLP,
In view of no statutory provision, my lord, how the appellate authority can appropriate to itself the authority to review its own order. That is the moot question. First. Second, my lord.
That is an academic issue because now that order of the original authority itself is now challenged.
No, the second question, my lord, on the very same day, without issuing notice to me, an order is being passed behind my back. These are the two important issues, my lord. And then we will come to the fact as to whether the drug qualifies to be under the category which has been projected by my learned friend. There is not an iota of evidence on record, my lord, that the death has occurred due to consumption of cough syrup.
The entire nation has been.
My lord, with great respect, my lord, these observations are harming more to us, my lord, because there is nothing, no material on record. I put my head on a platter, my lord. Let him show a single document which links the consumption of cough syrup with the death of the children. I am out of the court.
Not concerned with the death.
Please, my lord.
We are concerned with violation of the conditions of license.
No condition has been violated, my lord, with great respect.
Ethyl glycol or ethyl glycol
Now
is used in a medicine which is propylene glycol. It's a breach of the conditions of the medicine per se.
With great respect, my lord, there is no violation of any of the condition. I was given the license to manufacture the drug as per the BP standard. I have tested the propylene glycol as per the BP standard. The drug department has tested the propylene glycol by IP standard, my lord. If you are changing the rules of the game in between, I cannot be faulted.
There is no change of the rules of
My lord can see my license for a moment.
the license does
My lord can see my license for a moment. What are the conditions?
says diacetyl.
My lord, I bow down to that. Propylene glycol did contain ethylene glycol and diethylene glycol. But if I put a question to myself, whether I was mandated to examine that, the answer will be no. Because at no point of time, the BP parameter.
In fact, admittedly, you are a manufacturer of that.
That's correct, my lord, as per the BP standard.
Could not contain diacetyl glycol.
My lord,
this is a medicine, so it's a question of absolute.
No, my lord. My lord, with great respect, this is incorrect perception. My lord, let me clarify that. With great respect, I am the manufacturer of the drug which contains solvent as propylene glycol. As per the BP parameter, I am required to test the propylene glycol. I tested the propylene glycol as per the BP parameter, which is found to be in conformity with the standards laid down in the rules. Now the drug department, what does it say, Your Honor? The government analyst what say? It changes the rule. It tested the propylene glycol as per the IP parameter.
Drug and Cosmetics Act, the government analyst's report becomes binding until and unless you take an objection.
My lord, there is a caveat. My lord can see the report of the government analyst. Please see the report of the government analyst.
We are not going to go into the.
No, my lord, but please, with great respect, my lord must hear to me. My lord must hear to me.
We will hear you.
No, my lord, see the government analyst report for a moment. We are meeting the parameter as per the BP standards. How come IP parameters comes in between? My lord can see the government analyst report for a moment. Even otherwise.
Just listen, please. And to listen also. The first appellate order, which was reviewed by the appellate authority, was palpably illegal. That order warrants interference. The only way to so that you don't feel that you have not been heard, we set aside both the orders. Appellate original order as well as the review
order and the High Court order.
To decide the appeal again after hearing.
Please, my lord.
And till then, this stay will continue.
My lord, my only submission would be at this juncture, my lord. The appellate authority has passed an order against me, barring me from producing drugs which having the propylene glycol as ingredient. Abronal cough syrup, my lord, please bear with me for a moment. Docone Max and Abronal. I am not manufacturing, but my entire manufacturing license has been cancelled.
That's a report.
So, my lord, there are 15 other drugs which are being manufactured by me. So, why I am being penalized for a drug which has not been tested by the authority? I can understand Docone Max, Abronal. I put a statement before this bench. I am not manufacturing that.
The suspension of license need not relate to the drug. It would be in respect of the misdemeanor of the.
Milord, you have only tested two drugs. Milord, with great respect, Milord, please hear me out.
No.
Two drugs have been tested.
What the Honorable Chief Justice has proposed to you.
Milord, I bow down to that. I am only making a clarification if Milord can permit me to manufacture the drugs other than Ambronel and Docman Max.
Mr. Singh, this argument you will raise before the appellate.
Milord, I will be raising. I am only invoking the compassion of this honorable court for the woman movement. For the last 2 years, Milord, I am suffering without any fault of mine.
We set aside all the three orders.
No, Milord, with great respect, there is no fault of mine. Please let him show a single document which can link the death to the consumption of cough syrup.
This is merely a triggering point.
Milord,
Glycol cannot contain diethylene glycol. You are fully conscious.
Milord, I am fully conscious. I tested as per the BP parameter.
Ethyl glycol are poisonous.
Milord,
What are you saying?
please, Milord, please try to understand. I tested as per the BP parameter. I was not supposed to test as per the.
Mr. Singh, that till now we have not understand, then it's your bad luck, what can we do?
Milord, we
Our
set-
capacity
You're
has gone.
getting an opportunity to argue.
Please, Milord, we'll do that.
Complete authority.
As well as we'll do that, Milord.
Milord,
Milord can give me the right. I will raise all these issues before the appellate authority. No issues.
For the
all
appellate
three orders, Milord.
Leave granted. We have heard learned Relation Solicitor of India on behalf of the appellant.
Because I appear for the respondent number 226 because the state.
Okay.
Respondent number 226 plus is the state supporting the case of the petitioner's plus.
As well as Mr. Dinesh Kumar Goswami and Senior Counsel on behalf of State of UP.
Milos.
State of UP. Mr. Singh has been heard, Purana on behalf of the contesting respondent number 1. Next, in our considered opinion, the appellate authority under the drugs and cosmetic.
Please, Milord.
Under the drugs and cosmetic rules 1935. Had on both occasions, namely, while passing the order dated 11th August 2023, whereby the appeal of first respondent was allowed in part, as well as while passing the review order dated 4th October 2025.
Please, Milord.
Consequently, both the orders are set aside and the appeal filed by respondent number 1 against cancellation of its license by the drug controller, is restored to its original number and file, with the direction to the appellate authority to hear and decide that appeal afresh. It is clarified that we have not expressed any opinion on merits of the case. Next paragraph. Till the appeal is decided by the appellate authority. It goes without saying that until the appeal is decided,
Milord, the cancellation is there, so
Also need to be set aside.
it does not need any qualification.
Milord, the order,
The suspension is there, Milord, so we are not manufacturing, so it may not require any qualification.
next paragraph. As a necessary corollary thereto, the implement judgment of the High Court dated 19th May 25 is also sufficient.
please, Milord.
I'm grateful, Milord.
Obliged.
There is a letter. There is a letter.
So, look,
Allow it,
So that your main petition is pending.
yeah, but I want some variation. I understand.
The interim arrangement will.
No, but I want some variation in the arrangement.
It is already stated.
No, your lordships have granted me, my lord, a limited protection. Kindly see, my lord, the last order.
Our protection is that the conviction shall remain suspended.
My lord, subject to not holding an office of profit. I was a minister, my lord.
Oh, you want to come back to ministry?
My lord, who doesn't want to be a minister?
Get the revision decided fast.
My lord, the Chief Justice is the order.
We'll direct the revision to be heard in 6 months, then you become a minister.
What a picture. My lord, it's not a case of, it's not a case of bribe. My lord, your lordship will remember, I told my lord the Chief Justice on that day. My lord, I started as a lawyer, Mufassil lawyer. I said my salary is,
Agricultural income was not disclosed.
I earned 1,000 rupees. So the argument is you can't earn 1,000 as a lawyer when you start. How much else will a lawyer earn in 88 million from the Mufassil? That's how, my lord. These are, my lord, all political rivals who are doing this. My lord.
That was on EWS flats. The case was about your EWS allotment.
And my lord, agriculture income is a large joint family of my father and 4 uncles.
They are saying large tracts of land were owned by you and your family, and you portrayed yourself as economically weak person.
My lord, 20 people in one joint family, my lord, 4 uncles, father and us, my lord.
Let the High Court.
Very well, but then 6 months, my lord, lordship. Otherwise the tenure will go.
538 of 2025. Filed by the Commissioner against with conviction and sentence by the court below is pending consideration before the High Court. Since his prayer for suspension of the conviction, for staying the conviction, and consequently permitting him to contest the election was declined by the High Court, that the petitioner has approached this court. On 22nd December 2025, while issuing notice, this court issued the following interim directions. Para 5. Next paragraph. The above stated revision application is still pending before the High Court. You have been elected to us. The petitioner has been meanwhile elected to Maharashtra legislature.
I was already there, my lord.
Already.
I'm already an MLA. I was a minister by virtue of this, my lord. I remain an MLA.
24 you have been elected.
Yes.
That's already. Revision petition is pending before the High Court.
My lord, I can only add one thing.
Dispose of this.
I had a blanket stay of conviction in the court below,
With a request to the
before the first appellate court.
to decide the pending revision application expeditiously. The interim direction issued by this court on 22nd December 2025, as reproduced above, shall continue to operate during pendency of the revision.
My lord may say expeditiously, preferably within 3 months or 6 months. By the end of the year, my lord.
Preferably within 6 months.
I am grateful.
Please, Lordship, this is a. Yes, your Lordships. Stay, your Lordships. Stay of the High Court order.
Your Lordship, I'm
Yes.
appearing for the respondents. I'm appearing for the respondent in the matter. Your Lordship, the question is, Your Lordship, the academic session is going on, and ultimately, Your Lordship, since we're just looking at, that the matter may be disposed. So, Your Lordship, it may be, we are fine by giving consent to the transfer. The matter may be transferred. All, Your Lordship, if I may.
For you, they are before us, you are asking us to issue a direction in your favor.
No, my lords, I'm saying I'm giving consent to the fact that the matter may be transferred from High Court. We filed this written on 17th April 2026.
Here is a transfer.
Yes, CBS.
Please, your lordships, petition.
All right, then
So
do it.
CBSE has filed a petition.
Say,
There was a matter filed on 1st of July.
You are for the Union of India.
I am for the petitioner R1,
The CBSE.
Ariman Dutt Mathur.
She is the writ petition.
Like counsel for the contesting response number 1 and 2. States that he has no objection if the transfer petition is allowed. And writ petition civil number 5320/2026 pending before the High Court of Delhi is transferred to this court, to be heard along with the pending cases on the same issue.
May I just make a further request that I was making? Your Lordship, since my petition is first in point of time, the counter affidavit stand filed. Since we filed just 1 week after the, Your Lordship, if this petition could be just, considered as the lead matter, since the pleadings are complete and we're in the third,
That we can't promise that.
it's in the third month of this session.
All these cases
Please, Your Lordship.
make request on that day when the other matters are also there on board.
Please, my
Now,
lord.
the others are not here, so you may make that request next time. When the
Please, Your Lordship. So a date may be fixed, Your Lordship. Since it's the third month and the language studying has been stopped. It's been abruptly stopped.
When we will finally hear on that day, you point out, then in view of this, the transfer petition is allowed. The petition so pending in High Court of Delhi is ordered to be transferred to this court. Track the transfer petition along with so case.
Obliged, Your Lordship.
Please, my lords.
Yes,
This is the application filed in T.N. Godavarman's case, my lords, on behalf of the state. That is 88067. Seeking clarification of 2 orders, my lords. In fact, what has happened is, before the Honorable High Court, a petition is pending, which talks about having a permission from National Board of Wildlife, mandatory in case mining has to be undertaken within 10 kilometers of Asan Wetland Reserve. Asan Wetland Reserve primarily falls in Uttarakhand, my lords. Now, what happened is, initially there is an order of 2015 of the Honorable High Court of Uttarakhand laying down that as far as the 10-kilometer embargo is concerned, it will be total. There is no permission regarding NBL or not. That happened to be modified by my lord in February 2024, my lords, by order dated.
Where, what is the number of your application? Where is that?
88067, my lords. Of 2025, my lords. Initial one.
Orders.
No, my lord. What happened is the initial, there is a 2015 order of the Honorable High Court of Uttarakhand.
27/2015.
After that, the matter traveled to this Honorable Court. Now, this Honorable Court on 14
Just a
to.
minute, you are state of Himachal.
My lords.
Here is 88067.
My lords.
All right.
Amicus is here.
That 10-kilometer issue.
Yes, my lords. It's primarily because of that, even Himachal is suffering. In fact,
2025.
I am for Uttarakhand, my lord.
Should be here.
My lord, I could not file any affidavit in this matter, my lord.
In fact,
in fact, we are agreeing with what Himachal Pradesh is asking as well as what Union of India stand is there. Union of India has filed its affidavit from para 15 to 21. We agree with that.
In fact, they are also agreeing with Himachal, my lords.
Yes. All are in consensus.
Well, in fact,
because they are related to conservation reserve. Conservation reserve is different from eco-sensitive zones. So the parameter which is applicable on eco-sensitive zone cannot be applied on conservation reserves.
So that is the moot question.
And our difficulty is when Uttarakhand High Court passed order in 2015, we approached this Honorable Court. Our SLP was dismissed as withdrawn. With the liberty to file review, we filed review. That review was also dismissed. Now, all these things were noted in order dated 14/2/24.
You are appearing for union.
For state of Uttarakhand, my lord.
Uttarakhand. So in any case, Goa, Uttarakhand, the directions are come.
नमस्कार साथियों, स्वागत है आप सभी का हमारे इस लाइव सेशन में। आज हम एक बार फिर सीधे जुड़ रहे हैं भारत के सर्वोच्च न्यायालय माननीय सुप्रीम कोर्ट की लाइव कार्रवाई से। कोर्ट रूम में आज देश के कई गंभीर और महत्वपूर्ण मामलों पर सुनवाई हुई है। इस कार्यवाही के दौरान आपको देश के जाने माने वरिष्ठ अधिवक्ताओं के बीच बेहद शानदार और धारदार बहस सुनने को मिलेगी। कानून के दिग्गजों के तर्क और माननीय जजों के सवाल आपको बहुत कुछ नया सीखने का मौका देंगे। आपको बता दें कि हमारी यह लाइव स्ट्रीम पूरी तरह से केवल शैक्षणिक उद्देश्यों के लिए है। इसका मकसद देश के कानून, अदालती प्रक्रिया और वकीलों की दलीलों को आसान भाषा में समझना और समझाना है। तो कानून की इस बारीक समझ और लाइव अनुभव को जानने के लिए हमारे साथ बने रहिए। माननीय सुप्रीम कोर्ट की लाइव कार्रवाई अब शुरू होने जा रही है।
That's specifically listed for it to be listed on the 5th of August. It's not showing in the main list.
This is a language issue where the children are having that difficulty. They're stuck in the middle now.
Lordship, may I please make a mention?
On 20th August. That's why all matters are being.
The main case had been.
This is the main case.
Main case, my lords. This is the main case, my lords.
Yes.
This is the Yashika Bhandari case, my lords. If I may just present this, my lords, to your lordship. The entire batch was listed.
In fact, next week, I think there'll be a difficulty for the Solicitor General. Your Lordship remembers, he said he's leading some delegation of the UN. So next week may be difficult for them. It was slated for tomorrow, my lord.
20th is not week after next. 20th August is what it is showing.
Yes, my lords.
Yes, but that week, the Solicitor General is not here.
Because he's leading UN delegation.
Next week.
From 10th to 14th is what he meant.
17th onward, he is available.
Even then, there's this urgency. We thought next Wednesday. That's what.
Must have gone only because every day fresh letters are being filed.
No, that is
Problem for us.
By tomorrow, if it can be listed tomorrow, because for example,
I can't
children
now promise for tomorrow because now it's too late. Let me see what can I.
Could your Lordship try maybe
My lords,
Thursday?
it can come on Thursday or Friday. My lords, in fact, what is happening is there's so many children who are, whatever subjects they are chosen, that they are not getting taught in. And this new language, they don't have teachers or books at all. So therefore, children are actually sitting in classrooms without a subject teacher or the books being available, and nothing is happening. We're in August, my lords.
Clarified by CPSC.
No, my lord. That's for 9th, 10th, 11th, 8th, 9th, 10th. We're talking about 5th.
Class 6 also.
Even class 9, the children are actually spending time doing this without any books, without any teachers. That is the problem. They still have a third language. They are learning advanced chemistry, advanced maths, but at the same time doing this.
And if I may, my lords.
But class 6 is the cutoff class where they choose.
My lords, the relaxation, what it said is that we are providing the relaxation from class 7th onward.
Correct.
But
because-
class 6,
and
yes, my lords.
The logic, as we understood, was the choice is made at the class 5 and 6.
Yes, my lords.
So once you have already in 7, you have already chosen.
Yes.
I
So
think the
that's
point
the-
that I think we had not made clearly was this, that they've already chosen the languages in 1st, 2nd, 3rd, and 4th. When they go into 5th and 6th, because this new education policy 2020 comes into effect from 2030, they've brought it into effect 4 years in advance. As a consequence, these children now who are in that span, who have finished 3rd and 4th, are in 5th and 6th being told to eschew 2 languages that they've learnt 4 years. That becomes very difficult, especially in many of the states. We don't have that many language teachers. 22 languages have to be taught as per this policy.
Right. The bouquet is of 22.
Yes.
But if you see the options,
Yes.
they're mostly in 4 or 5 languages.
But unfortunately, the policy itself requires all 22 to be offered, which is why, I mean, they should have applied their mind better to having such a.
And also, my lords, the
Possible for schools.
It's
across
not.
the
That's
absolutely,
exactly. That's our
that should not be implemented.
our stand.
In,
Madam, there is a difference of the entire 22 languages on offer and seeing a realistic access of language options
Correct.
across the board in various states.
yes.
That's what we are saying.
In fact, my lords,
It would essentially be Hindi or any one of the regions.
in fact, my lords, in Kolkata, which we are representing a lot of students of, their language options are Hindi, Bengali, and Sanskrit. But they don't even have the language.
Correct you, in some of the northern districts, it would be Nepali.
You're absolutely
Yes.
right, my lord, but they don't have
Lordships are
books,
right.
my lords.
Varies from region to region, and Mr. Gopal, it would in all come to around 8 to 10 Indian languages.
Yes.
So far as foreign languages are concerned, 3 to 4.
This is,
Nobody opts for Chinese or
this is what we are saying.
language like
Absolutely.
This is precisely what we are saying.
We
We
agree
are
with
exactly saying what your lordship is saying, and we are saying, therefore, apply your mind. What?
And-
How can you suddenly dump this on people in the middle of it?
that's only the spectrum they have given.
No, my lord. Unfortunately, no. I wish it were only the spectrum.
Working out the proposal or the policy
Yes.
is what we wanted to do, because in the last
Correct.
occasion, I think we were of the view that let us see how the creases can be ironed out.
Yes.
Yes.
And CBS has already done it by relaxing up to class 7. We can take a call on 6 because our understanding was 6 is the standard.
It's even before, my lords. It's even before.
that's-
It's not at class 6 that it starts.
Something like this. They are taught, but from 6th you start a new language.
No, my lords. In fact, from class 5th they start.
Which, yes, if you are exposed to that language, it is comfortable.
Yes.
Otherwise, you start it anew.
I agree. I think maybe we could take your lordships through that to show that actually the cutoff is not 6. It's much before
It is
that.
much earlier.
That's the
It's
problem.
much earlier, my lords.
Some schools class 4, but additionally for class 9th, we are requesting a rollback because 9th is when they're preparing for their 10th.
You may consider it either tomorrow, day after.
Lordship, may
if
please
it-
make.
if it's-
We will find out after.
Very well. ma'am.
Obliged, my lords.
Harsh and coercive direction from the Honorable High Court. I want to challenge it through the SLP. Now, I'm not insisting the court to take suo motu action. My SLP is ready. All I want from the Honorable Court is to kindly get it listed by tomorrow or day after tomorrow.
Tomorrow.
Janab, the problem is the case is now listed for 11th of August. Now my petition will render infructuous if it would not be heard.
Means tomorrow list is must be.
Day after tomorrow, please, sir.
We will see.
Janab, the direction is to produce the petitioner before the Honorable High Court through the Commissioner of Police, Gurugram.
File the SLP, just give the number to us and have you filed it?
Yes, it's ready. I'm just,
File, don't make advance booking.
sir. Sir, Lordship is already aware what is happening with me. I was about to mob lynch.
Go and
The documents are with the Lordship that how my document has been for the legal documents. Kindly at least, sir, I am a single woman. How long I will keep
We
struggling?
will hear, so nobody will be able to hear unless you file the petition.
File it, get it.
Go and file the petition, give
Thank
your
you,
number
thank you
to us.
Kindly list it day after tomorrow. Thank you so much.
File it and cure the defects.
Highly obliged.
Make sure that there is no defect and then it will be listed.
Sir, defects should be raised by the DR. Okay. Right.
All right.
Sir, otherwise there would be no use of this. And if if the Honorable High Courts will pass such directions, then how the police will respect us? They already disrespecting us in all the ways. And you are saying the police to produce me the petitioner before the court. Why there is no direction for the respondent? I am the petitioner. You can dismiss my petitioner if I am not appearing physically.
We will list your petition.
Highly obliged.
Yesterday you should have been part of the delegation. I would have resolved your issue here and.
But Janab, the High Court is also under your domain. You may kindly direct them.
Hundreds of lawyers were there yesterday. You should have also been there. He's also.
Highly obliged.
To 25, just call it. Plus 25. Plus 25 is this issue of data protection. That's the first direct case that has come to your lordships squarely.
It was filed prior to the DPDP Act.
DPDP Act, but dehors that there is another statute, and this is the first time the direct case has come to your lordships where allegations are square, admitted in the writ that data is being transferred. Question is what protection you will have. The data is not just transferred to people in India, but financial data goes abroad. Europe, United States, because I have circulated a note last time also, your lordships had occasion to see that note is dated for.
Yes, there is a very comprehensive note you also.
Yes, please. Question is how we apply the principles that your lordships have laid down so far as the right to privacy is concerned, so far as data privacy is concerned, my lords. the RBI has filed a response. On the last occasion, the Solicitor General was appearing. Let's.
Well, I'm for RBI. We have already filed the response. I'm for RBI. I have already filed the response, but this note I have not received.
The Solicitor General asked for it. It was given to him last time.
It's for RBI.
Yeah, no, the Solicitor General appeared for the RBI last time. So we had given it to him, but I can of course just give it a copy. Just give Mr. Babu a copy. It is done. Last order directed that it has already been circulated.
What has been circulated?
It has been circulated to all minutes. In fact, some of the people have even filed their responses to the note. Responses to the
order notices.
We are appearing for.
I will file a response to this note also.
I'm appearing for 3 of the CICs. Even we'll have to file a response because there are certain.
India has not filed it. No, but why you are delaying your response? This
No, we have already filed the reply to the writ petitions. The response to the learned amicus's note we'll have to file.
Please don't file any response to this note. Note is only for our assistance. If you want to draw some help from the note, you take it. Otherwise, don't take it.
Very well.
You can submit your own written submissions.
Very well. We'll do that. We'll do that.
I appear for the 4th CIC, Manoj. I'll also do the same.
So, but are you ready? Because this matter, we would like to hear it. There is some important issue touching around the right to privacy. Where is the learned solicitor? Who is the union?
I beg to appear for union, Malad. We have prepared some comments on the amicus's note, Malad, but on the third point, that amicus has pointed out that data is going abroad, Malad. I wanted to compile the data that no data is going outside. There is an embargo. RBI's affidavit is on record, but I would have preferred if your lodges may call it after 2 weeks. We'll assist your lodges with our written note, Malad. Otherwise, our counter affidavits are on record.
Madam Asurya, then do one thing, that whatever is mentioned in the note,
yes,
and it's not, we don't need a counter note. You can file a explanatory supplementary affidavit.
Please,
suppose the learned amicus has prepared the note on the basis of some presumption, or he has drawn a inference that this is how data is traveling, or data is being transferred or disclosed. There you can you can take a specific stand that it is being done or not allowed.
Please, Manoj. Lordship may call it after 2 weeks, Manoj. We'll be ready and assist your lordships.
Like on the request made by the Judicial Services of India and other senior scope counsels representing the respondents, pose this matter for further consideration on so date. Meanwhile, Union of India may file additional affidavit if so required.
I'm grateful.
Grateful. 26 and 27.
Your Lordship, I appear for Bar Council of India. In this, we had submitted that sealed cover for your Lordship's consideration regarding the mechanism to be followed for co-option on 14 July. That's with your Lordships.
Because I appear for the Bar Council of Delhi, my lords, I was only informing that our counting is complete and we will be filing a formal status report placing all the details before my lords.
But there are certain applications filed before your lordship. What has happened is nobody is opposing this, Lord, giving representation to the women members. That we have said so in our IA also. But it doesn't mean that the statutory mechanism under section 3(2) should be dispensed with.
Yes.
Because what happens is, Lord, in the process of counting that, one who has got 2,500 votes stands eliminated. A lady with 46 votes, doesn't matter. Give her preference, but don't count her second transferable vote. How can that not happen?
That whether Parliament can increase it,
yes,
or the Bar Council can do it.
Please.
One. Two, if it is increased, then election has to be
Of the total number.
The total number.
Yes, absolutely.
We all voted for 23, my lord.
So, if at all there is an increase, that will be a completely separate issue. But we are not mincing the words. We are very clear in mind. The moment it is increased,
it will be out.
women will get
Adequate representation.
Out of the total.
Out of the total.
Adequate of the total number.
Obviously.
11.
Yes.
Your Lordships, may I make a submission?
Mr. Giri, yes, please.
Lords, I'm sorry that I'm appearing on a VC, but a couple of things, my lord, which I wanted to bring to your lordship's notice. Firstly, my lord, the Dhulia committee met, my lord, for about 3 days, heard various stakeholders, and a report on co-option has been circulated to your lordships on 16, it is noted in your lordships ROP dated 16/6/26, office report dated 16/6/26. We have not served a copy on anybody because we thought we'll first circulate it to your lordships, and subject to your lordship's approval, then an order may have to be passed by your lordships on that. But on the question of co-option, the committee has met on several days, heard all the stakeholders, including the Bar Council of India, and we have taken a decision, my lord. It should have been brought to your lordship's notice by the Bar Council itself on an earlier occasion. My lord, if they do, what they did, my lord, now is to pass a resolution increasing the strength across the board. My lord, that we took suo motu notice, the committee took suo motu notice of it. And then on a day, my lord, we called upon the representative of the Bar Council of India to say whether such a decision has been taken. My lord, he consulted the chairman and the vice chairman of the Bar Council of India as it exists now, and he said, no, this is only a proposal, that we have not taken a decision to increase the strength as such. No, my lord, it's up to your lordships, my lord. We cannot be seen as, my lord, giving any suggestions as it were, except that when your lordships asked us to look into this question of co-option, we have taken a decision, we have made our recommendations, we have placed it before your lordships, only for your lordship's internal viewing. And once your lordship feels that this it can be gone through, or it should be tweaked, then, my lord, the necessary orders may be passed by your lordships. No, my lords, the one aspect on which,
if we can have a look at this.
just a moment, please. My lord, on one aspect, my lord, we had made deliberations, my lord, and so that it could be brought to your lordship's notice. One is that, suppose, my lord, the strength is increased now, it means that the elections will have to be held again. That means, my lord, all those logistics and all the efforts that have been taken so far, my lord, will have to be revisited again. That may not be something, and therefore, my lord, in the resolution that the Bar Council of India passed, where they say that the strength will have to be increased, and therefore the women's strength will, therefore 30% of the, that will remain as it is, but the strength will be increased, and therefore, suppose it is 25 in the beginning, it will be 25 after there is a strength without the reservation, and the reservation will stand separately. This is when, my lord, we said that will require an approval by your lordships, because after all, my lord, strength is fixed statutorily, and now that the elections are over, it obviously, my lord, cannot be in sync with what your lordships have held in almost all cases, that once the game has begun, one cannot change the rules of it. No, my lord, all that is required now is because there is a detailed consideration, my lord, on the question of co-option in the report that we have circulated to your lordships. And if your lordships are pleased to have a look at it, and then if your lordships pass an order, the results could be declared subject to whatever lordship orders that your lordships are passing in that behalf.
We are not privy to these.
Your lordship,
If we can be
I have not
given a copy
I have
of
not,
this, then we
we have
can
not
get
served a
back
copy
to your
of
lordship
anybody.
with our
would like to
suggestions.
We thought that your lordships will have to go through it, and then we'll serve a copy on the other.
No, we should also.
yeah, we should, we,
By the committee on co-option.
Your Lordship, as per the office report, they are there. They are not with me. I will seek instructions, as Mr. Giri pointed out, only to your Lordships they were circulated. Like we circulated the report only to your Lordships in sealed cover. If it's not before your Lordships, I'll make sure that it is placed
Let the
before your
issue of
Lordships.
single transferable vote be decided first.
That escaped our notice. It might have been circulated.
I will ensure your Lordship a sealed cover is placed again through the committee to your Lordships. I'll make sure of that.
No, it is already received in the Lordship Secretariat on 21/5/2026. And please have a look at the office report dated 16/6/26. Once the Lordships have a look at it, then further steps could be taken.
What is Mr. Giri?
Yes, my lords.
Can you apprise us what is the conclusion committee on the co-option principle?
The contents of the report, my lords.
Co-option.
The co-option principle.
Co-option. But I can, my lord, of course. It's there, it must have been presented to your lordships in a sealed envelope because your lordships are in a position to. Otherwise, if your lordships, please give me 5 minutes. I'll come there in person and hand it over to your lordship.
Single transferable vote, that should be because of counting. Lordship.
The whole result will change, your lordships, because of the transferability. So what has been declared now, your lordships will also come under us.
But that's
Court
subject
now
to
sitting
the-
in something altogether
That's
different.
subject to that.
Yes, your lordships.
With regard to co-option, my lords, there is always co-option available. Every state, there are 4 co-option seats.
Co-option, there cannot be a magic wand to satisfy everyone.
That's right.
Frankly speaking, some rule will have to be applied and let it be in a
Uniform.
way that does not cause any heartburning among the candidates.
Or
because tomorrow what will happen is that the winning candidate, woman candidate, will feel that I defeated this XYZ and now she is
Now she has come back.
having the same time. That will create problem.
Yes, sir.
It will also cause indirect heartburning among the male candidates saying that she has secured hardly 1% vote or.
And she is gone.
Yes.
Therefore, outside
I'm
independent, what
suggesting
your
something
lordship
else.
suggested is right.
I'm suggesting something else, my
lordships.
lord. Something else I'm suggesting, my lord.
Mechanism
Well,
has to be worked out.
on co-option, your lordship's suggestion is something
absolutely right.
everybody has accepted.
Co-op
So if your
beyond
lordship
25
passes
seats,
the order in
my
that
lord.
terms, co-option can be taken care of.
Your lordships and
I
have to numerical is
Co-option beyond
sufficient.
25 seats, I'm saying, my
There are
lord.
at least 5 women who have to be co-opted, your lordship. So one woman, your lordships, the chief justice.
Elected.
No,
5 elected,
5
2
co-opted, your lordships will be, I think, 2 women. So one, your lordships, the Honorable Chief Justice can suggest. The other, your lordships, is also, I just presented a new point to your lordships with regard to the regional representation. If there's no representation of any region, like in Tamil Nadu and Pondicherry, there's no representation of Pondicherry.
Makhija, can I interrupt
Yes,
you
sir,
for a
lordships.
moment?
So Chief Justice may
Whatever
also
Ms.
take our suggestions. Lordships may say that.
Makhija, can I just interrupt you for a
We'll
moment?
represent to the Chief Justice because we have
I think
My
Mr.
lord, these
Giri is
aspects
trying to
are
say
also
something.
taken note of by the-
May I make a suggestion, my lordship? Your lordship, that, oh, sorry, okay.
Mr. Giri, could you
Please.
come up with the
My lord, can I,
proposal?
my lord, we'll place further copies of this report that we have made. Could your lordships kindly take it up after 10 minutes, or would your lordships like to take it up tomorrow, my lord? I'll be.
Tomorrow.
It is a co-option.
Mr. Giri,
Oh, yeah,
what
on co-option also, on co-option also. All these aspects which have been mentioned here have actually been considered, and there is a very detailed report, my lord, penned by Justice Julia.
Please get back to us on this. We
Yes.
are proposing to empower or request the chief justices to make the co-option or recommend the co-opted members from retired high court judges or senior advocates of the bar.
Or as
Your-
per
your
representations given by us, your
My lord,
lordships
see,
as well.
that,
Because
that,
that
of
will
course,
also.
my lord, when it falls,
Yes, we will
when it comes as
represent
an
the
order,
Chief Justice, your lordships.
when it comes as an order of your
Lordship said
lordships,
that-
obviously,
We can't hear him.
Pattern of, Mr. Giri, this will be on the pattern of like you nominate members in Rajya Sabha, you nominate member in the state legislative councils, you nominate members in the municipal corporations, you nominate members in other elected bodies.
Even the courts committees also you nominate members.
An elected body. We
Yes,
are
yes.
giving a example of where the prominently the body is an elected body,
Yes.
but there are some nominations.
Nominated.
The same pattern, we can introduce it, and any practice ultimately, whether it is the ideal one or the best practice or the reasonably good or bad practice, that will be learned from experience.
Yes.
At least for the time being, we can adopt this mechanism.
This is the first.
Kindly
Lord,
senior
since,
member. It could be a senior member who's not senior. Lordships may keep that for the Chief Justice to decide, your Lordships, because there's
Lord, if
many
the-
interests over here, your Lordships. Let the Honorable Chief
Lord, if the
Justice
total
decide.
strength-
Carry on. No, he has not, the expert may not.
I don't.
Let's see.
Lord, he has done many things.
I'm sorry.
Then let him do what he will say, calculate this for single transferable vote.
This.
He's saying
Lordships.
this is Leah
I
committee.
think we have a committee. I think that committee will take care of it.
That's right.
Some idea being.
Your Lordships,
Co-option, Your Lordship.
Your Lordships, may I make a submission? Your Lordships, this lady who has actually contested, it should not become a disqualification for her.
It's not,
Yes,
can't be,
that's.
can't be a discussion.
Because if Chief
That will be
Justice,
left to the
if
Honorable
the
Chief Justice.
Honorable Chief Justice feels that if she is worthy of being co-opted, then this should not become a disqualification for her. That's
Your
one
Lordships
thing.
may leave it
And Your
open to
Lordship,
the Honorable
second
Chief
thing, the
Justice.
senior
This is going back.
designation, Your Lordship,
Pavilion.
make it senior member, not senior designated, because
Senior
there may be senior members who may not have opted to become seniors, say, taken a senior,
Well, I
still.
think your lordship suggestion was the best. Outside independent person.
Senior
For a senior member of the bar,
Senior.
technically saying that senior designated.
Senior designated.
A very stalwart woman advocate who never applied, who never sought to be designated.
Chronologically
And
senior.
with due respect,
They
ma'am,
would have contributed more to the bar, your Lordships. Non-designated ladies would have contributed a lot more.
You can say Chief Justice consultant.
this is going to.
Yes.
Yes, your Lordships, just keep it open for.
Lord Justice Bagchi should mute his mic.
By the fact that I'm standing next to her, by the fact that I'm standing next to a person who has been vociferous, it's in some way infectious. And I feel like saying something before the whole thing closes and my lord says. Because there is
Due
one
respect, my lord,
He's hogged
My
the
lord, I
dais.
hope your lordships.
kindly
have had a-
allow me to suggest, kindly allow me to give a suggestion, my lord. There is always a co-option with the bar council. 4 members, 2 members are always co-opted.
Please wait. Order is dictated.
But I hope your lordships have had an occasion to look at the report.
Two following contentious issues have emerged for our consideration. One, what should be the zone of consideration for the purpose of co-option of the women members of the state bar councils? 2, what should be the correct methodology of transferring stroke
Single transferable vote.
Single
transferable vote.
how to calculate the transferable votes, transferable votes amongst the contesting candidates, contesting candidates.
Particularly the women candidates.
Particularly women candidates. Question mark. Next paragraph. As regard to the issue number 1, we have discussed the issue in the open court with the members of the bar representing various states bar councils who are present in court. On a suggestion by the court, there is a broad consensus that Honorable Chief Justices of the jurisdictional high courts may be authorized to nominate 1, a former woman judge of the High Court, or 2, a senior woman member of the senior woman practicing woman advocate of the bar
As co-opted women member.
As co-opted women members of the state bar council.
Standing of the woman senior advocate may be mentioned.
Standing of the.
That may vary from state to state.
It'll vary.
High Court Chief Justice will know the senior most according to the standards of that particular High Court.
Of a fair standing, a women may. in our considered opinion, it will infuse objectivity, independence, and transparency in the working of the state bar councils. We accordingly order, we accordingly direct that 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 two women candidates to be co-opted in the state bar council shall be from amongst one eye, the former women judge of the High Court, of the jurisdictional High Court, let it be local High Court, because otherwise of the jurisdictional High Court, or to I, a senior, a woman, senior advocate of fair standing, from the concerned state.
It's woman member instead of advocate. Senior woman member.
Fair standing.
Member. Grateful.
A senior woman advocate having fair standing at bar.
Designated or non-designated, right?
But state oblique states, because many states have, Maharashtra and Goa is common, Pondicherry and Tamil.
And thirdly, your lordship's regional representation. Peculiar to the particular state.
Justices shall take into consideration all the relevant factors while nominating the
They created the bar on the election, elected women.
Cities have clarified that unsuccessful participation in the election of the bar council will not be a disqualification.
Grateful.
Very grateful. Deeply grateful, my lords.
Let me also prescribe time limit. Time limit would be important for the.
They'll do when.
Owing to the urgency of the issue, we request Honorable Chief Justices to do the needful at the earliest. It cannot look like.
The
One humble submission, my lord.
executive
There are
committees of the state
Bar
have to be
council can
constituted.
always co-opt other members of the bar.
The
The next
executive
issue is-
councils of the various bar councils have to be constituted, my lord, because election results are declared. They're waiting on the co-option. That's the only thing. Either it can be done without the co-option or with the co-option.
Lordships with the co-option, otherwise it will upset the whole results all over again.
We are indicating expeditiously so that the state bar councils can be formally
Declared.
I'm,
Yeah.
kindly allow me to
Single
suggest
transferable-
something, my lord.
single
Kindly allow me to
transferable
suggest,
Direction.
my lords,
To the-
bar,
we are coming to that. We are coming to that. On the second issue, it seems to us that there are varied opinions which require to be considered at which are required to be minutely considered by the high power committee presided over by Justice Sudhanshu Dhulia, former judge of this court.
Considered afresh. This is Julius.
Required to be considered afresh by the committee, by the high power committee headed by Justice Sudhanshu Dhulia, former judge of this court. In this regard, we have in this regard, the members of the interested members of the bar are permitted to submit their suggestions, stroke opinion to Justice Dhulia's committee within 1 week.
Yes.
Within 1 week. And on consideration thereof.
Why? Online even.
Yes, your Lordship, online.
Virtual.
1 week is ample.
Good enough.
Proud Justice Julia's office.
Your lordships, because I'm thinking of all the members who are outside Delhi, that is why.
Beyond Delhi, there is.
Very well, very good. I retract my request immediately.
The committee may accord an opportunity of oral hearing, before taking a final decision.
one humble suggestion, my lords. The bar council has always co-opt as many members they want, 4 members, 2 members. Every state is bar council is empowered.
But your lordship,
Let
a
those
direct
women
counting will
at
be in
6 and
accordance
7
with the decision of the committee.
Let those women at 6 and 7 be co-opt in that position, my lord, so that they can remain be part of the bar council.
Concluded.
Yes.
I know, that's right. But the way it has been done is wrongly done. If they
No,
come to
so
that
that means my friend is saying we'll open up all the results.
No, it doesn't take much time.
Let them take some opinion from them. Otherwise, this single transfer vote,
Option.
they just may not aware. So
Just 1 minute. Mr.
Bar
Bharti is saying-
councils shall be notified. But then this is subject to our direction for.
Correct.
If there is some variation,
Lordships approve.
some other resolution given by Justice Julia's committee, which we feel is in consonance to justice, we would reconsider.
That's right. Absolutely.
It's not going to stop the functioning of the State Bar Council.
Your Lordship may clarify that, because their idea is not to have them function yet.
That's not the idea. They are keen to get back into this one. Gopal Shankar Narayan, Lord, unnecessarily.
I'm not saying
Every
unnecessary.
matter,
I'm
this
sorry.
is what is
I'm
happening.
sorry.
Option,
The Vice President of the Bar Council of India is standing for the 20th time. I think some people should, after 15 years, you should give up the post to someone else.
simply targeting one person and going.
That's not the point.
This is why, it's all personal for them.
He's going on making some allegations. It's not correct. Lord, I contested Lord 3 times. Lord, I am winning. Now I am at 25th. Lord, it's standard.
I don't think this is a personal attack.
Not a person.
Right now, that is not an issue, I think.
Anyway.
You started it. You passed a resolution condemning me. I remember it. So don't tell me that.
Sir, there are people who are jealous of your popularity.
I confess, my lords, I confess. I'm guilty of that.
What a compliment. Gopal to contest. They don't dare to contest.
Yeah.
Don't have the guts, my lords.
Yes.
Democratic election.
Go out and contest.
So we are seeing in the Bar Council right from the very beginning.
Yes, absolutely.
And that you should be proud of your popularity, as my brother has rightly pointed out.
But had it not been for Lordship's intervention, I
as of
don't
now,
think
we are
Bar
talking-
Council
Lordship,
elections would have been ever streamlined.
At this stage, instead of giving the party to seek their redressal of grievances, if so, any occasion.
My lords, if I may make
Straight from-
one submission, my lords. Your Lordships, once Justice Dhulia's suggestions come to your Lordships, then we'll have to file fresh petitions, or these can continue.
So then,
Madam, if Justice Julia.
Not on the second issue, report will have to.
That's co-op.
Not on the second issue.
Wonderful Chief Justice
Committee will have to
allowed
have a
to
report.
co-op.
You.
Well, it's the independence of the Bar Council.
Yes, your Lord.
Bar
the
Council
single
is
transferable
statutory
vote
body.
Done.
Report
If
to be
Honorable
given.
Chief Justice is allowed to co-opt, it will intermingle the functions, my lords. There will be no independence of the Bar Council.
Very well. Very,
Peace will prevail.
very
The
grateful.
functioning of
But
the
single
state councils
transferable
can
vote.
go on.
Whatever their opinion, report, etc., should be before your lordships.
No, but we are disposing of these matters because if somebody will be aggrieved, they will challenge that.
That's best.
All right.
We have told them that to take a final decision.
Let's,
We have used the words. If somebody will ask for judicial review, we will consider that in an independent. body.
Lordship.
humble submission.
Great.
Main pertain to challenge to rule 32. That main petition, that question of law may be left open.
Question of law with respect to, the question of law with respect to legality of rule 32 is kept open.
Rule 32, since elections have now been held, they wanted to extend it eternally below.
It's kept open.
Yes, so that question, because they may try to do it again in the next election. So that question of. I'm so grateful.
Obliged.
Thank you.
Deeply obliged.
They are only Bar Council.
कोई brief नहीं है, कोई
कुछ नहीं है, कोई
Was that correct?
My lord, your lordships issued notice in 2020, my lord. Lordships framed questions of law in 2022. And in 2024, there is one order, my lord, without hearing all the affected parties, my lord. And that order says that Even the 7-11 will not continue. May I show you the one order, my lord? Just see the order dated.
Lordship,
12th
none of that is
December.
on board today. There's only a contempt which is on board. So
No, that
my
contempt.
learned friend is addressing the main matter. Only a contempt out of that batch is listed today, as per the registry noting in the cause list.
Contempt is listed.
Yes.
Only contempt is listed, Lordship. My
But
learned friend is addressing on the main matter.
No, please wait. That contempt is totally based on the order dated 12th September. The issue is this, my lord. Just see the order.
Somebody some 40s.
Dated 12th December 2024. Just may I please allow me to read that order, my lord? How this order was passed without hearing the affected parties, even without hearing us, my lord. I have not filed contempt.
His matter is not, he's addressing the main matter, Lordship. The contempt is the only matter which is listed.
Today we list the main case.
My lord, only I am only
Main case alone.
next week, my lord.
We are listing to one now. Next week we don't have time.
What is happening, my lord?
Some matter, part of the matter is going on. Item 29, there is a letter circulating.
Grateful, Lord.
24 onward, the matter could not be taken up.
And entire batch should be listed, my lord. Entire batch of the petition.
Lordship, only a request item 28, let that.
Digital arrest.
How are you?
Which item? Just to be hearing the 28th.
Let me mind note.
Sir, we were requesting item 28 that date should be given because from 2024 on the matter could not be.
29 letter.
No, we are requesting for 28.
29, there is no letter, my lord.
December
29,
24 on
there
the
is no
matter could
letter.
not be listed, Your Lordship.
Yeah.
Item number 28, Your Lordship. There is a.
Just said all matters will be listed, main matter.
I was requesting only date some early date to be given, Your Lordship.
Early date because
After December 24, the matter is not being listed, Lordship, for hearing, Your Lordship. From December 24, Lordship.
What can we do? List it.
obliged, my lord.
Below 29, this gentleman is continuing as a minister now. It is almost 8 months now. Your Lordship's judgment very clearly says that 6 months consecutively.
Mr. Vikasing, unfortunately, in item 29, we don't know, the petitioner council has applied for.
Your Lordship, we are
No,
appearing
my
for
lord.
petitioner. Mr. Vikas is led, we are led by
But
Mr.
why
Vikas.
did you file this letter of circulated for adjournment?
Lordship,
No.
we didn't file
We
any
have not
adjournment.
circulated any letter.
Lordship, we have not filed any adjournment.
Who's the council's name, Lord?
There is no letter in 29 today.
There was no letter in 29. They were given time last time.
One kindly have it on Friday, my lord, in that case. If your lordships can have it on Friday, my lord, 29.
We will have to have it on Friday, Mr. Mehta. Why, what's happening here?
7 months and
26 days.
26
Solicitor, are
days.
you appearing for the?
I am for the petitioner, my lord. I am for the petitioner.
No, you are, Mr. Vikasing, you are appearing for the petitioner. We just want to know,
He's appearing for
The
the state.
London SG is appearing for the respondent.
For the state. He's appearing for the
I
state.
am for the state, my lord.
for the state. And who is there for this minister?
Well, there is a question of law. Mr. Vikas Singh, my lord, seems to be right. There are two possible ways of looking at it. Kindly have it on Friday. Will, my lord, maybe I might
In my
advise.
view, this has been decided by your lordship, lord. In this judgment of,
No, the Punjab judgment is different.
no, specifically the Punjab judgment says that once you become a minister,
The 6 months consecutively has been interpreted that you have to become an MLA within 6 months from the time you first became a minister. Very clearly it has been held. So he can't continue beyond six. What has happened in this case here, he has continued more than 6 months. He's continued in 2 spells, and in Punjab exactly the same thing was being done.
Take 71.
Probably some letter has wrongly come in this file. That is why your lordships have.
Well, kindly have it on Friday, my lord. We will, I will look into it, my lord. So what can be done?
Then on Friday.
Friday,
Please, sir.
deeply obliged.
My lords, certain directions. My lords, and I have also submitted a sealed cover yesterday with the draft directions and the government's status report also comprises some directions that they are seeking.
Page 24 of the report.
Yesterday's sealed cover maybe.
There's a fourth status report filed yesterday.
So also, the attorney had also circulated an
That's
application
right.
seeking certain directions. Your application was.
In fact,
Yes.
what I have tried to do is I try to.
We have combined and I've collated and added both
You
the
have tried to
government as
incorporate.
well as the Micah's submissions. And copies have been served on the learned AG.
So some directions are against RBI.
No, not exactly again, because you've lost kindly now the fourth status report, which was filed yesterday. In fact, we are trying to incorporate a good part of Wellington's suggestion, but we don't have a friction in the working of the system. But sometimes I don't want to say anything that we don't want to be too adventurous to leap into the future before we know where we land. So we have been very careful in trying to do it. Kindly turn to page 24 of this fourth report.
In volumes.
In fact, it incorporates good part of the suggestions given by the learned amicus.
Background of that, complaints have not drastically dropped and the amount involved is also now reducing.
That's right.
Thereafter, you have sought certain, just a view to effectiveness that you are seeking some direction to RBI and.
No.
So we propose to issue those, so that.
Very well. If your lordships are placing my last request, and in fact, in the last this report which we have placed yesterday, the slight progress there are. Some more suggestions have come in, but by and large, it takes note of the same kind of suggestions earlier. So if your lords go by the earlier note, I don't think they're in difficulty. But I thought this is a little more nuanced and. You should probably better take note of the fourth report, which has been circulated yesterday. Courtmaster, you are not able to look at it.
My submission, the sealed cover of yesterday, takes into account the directions sought at the last status report because this was prepared before the receipt of the submissions from the.
In the fourth status report.
That's right. Page 24.
There are 9 page 24 and 25.
That's right.
Clarification directions.
Your lordship, please.
We are issuing those ones.
Very well.
And similarly, you have also issued.
Well,
So.
Well, if I may just point out with respect to what is there in 24 and 25, I've made a short note on what additional, because the learned AG has actually taken into account what my suggestions were in the earlier submissions, my lords, and those are incorporated from serial number 5 onwards. Therefore, only some minor corrections are sought with respect to the directions from page 24 onwards. I may just be permitted to point that out, my lords, if I may. And that will then capture what I have submitted in my seal cover yesterday.
Direction which you have, so will they take care of the?
These things from slide modification.
the government's plus my suggestions.
First, what are the changes you want?
My lords, if I may, as far as the serial number 2 is concerned, serial number 1, they seek directions for RBI to, that we don't have.
Serial number 1 is all right.
Yes.
Now, serial number 2, what do you want?
As far as serial number 2 is concerned also, I do not have any,
Now,
but there is an addition I'm seeking. Now, there are 2 modules that have been introduced by I4C, which is for grievance redressal and money restoration modules. This is supposed to predominantly take care of victims' requirements in terms of recovery of money. But there is no awareness with respect to how these 2 modules will function. And therefore, I've only asked for an addition of awareness.
Awareness.
Yes.
No, in fact, you'll also look at point 5 of the report.
Yes, I'm coming to that.
Make a comments. We will
Well,
just-
This is specific to 2, which is critical, my lords, because that is something
Yes,
that victims have, because what happened is when these,
Number 3.
my lords, number 5 directly, my lords.
Number 5. So,
The rest I don't have any additions on. In number 5, the last line in that page, page 25, which says awareness programs about cyber crimes. I'm seeking an addition there of awareness programs about cyber crimes and remedies.
plus 2, plus 2, plus 2.
Plus 2.
So you want 2 to be repeated or incorporated in 5 also? 5.
No, here it is slightly different, my lords, because in 2 it is,
Awareness, corporate should allow times also awareness about redressal.
yes, because remedies are something that no awareness program carries any.
Very good.
Therefore, I'm only, and this is different because in 2 it is about the modules. My lords. Now, if I may go to 6. lords. This is to consult with intermediaries and banks. Now, this is something that I have sought for certain specific directions in the context of where there is a mention made in the earlier status report about kill switch. There is nothing with respect to intermediaries other than this.
Of now, we are
I am not,
the kill switch direction.
I am not asking for a direction on that.
Making general directions with regard to intermediary consultation.
My input is, my submission is also to in the same lines. I am not seeking.
The moment,
Let me just come. I'm not seeking directions with respect to kill switch. I'm only saying that IDC may take up what are the alternatives and what is feasible, because what was submitted in the earlier committee also.
It's there in
Yes.
the words possible technological steps.
Yes,
They are general.
yes,
So that would include what you were suggesting on kill switch.
That's
and
right.
yes.
Or
Specific interventionist technology.
It
Or
may also
any
be
other
considered
alternative.
by them is all I'm saying, my lords. As far as 7 is concerned,
can I also say one thing,
Yes.
Your Lordship? If she permits you. Yeah, of course you'll permit.
Lordship, there is a request. There is a request to point out 3 fundamental things in this.
may I complete? As far as 7 is concerned, that is a little concerning because the subcommittee for shared liability and all for victim compensation was formed under IDC many months back. No report or status report has been filed. Now, what is being requested is for feasibility of a shared liability,
Yeah, of course.
not for a proposal of a shared liability. I'm only making a request for the word feasibility to be modified to say proposal.
No, I
That's the-
suppose feasibility comprehends first an analysis, and therefore if it's not possible, then there is,
Just that one proposal.
it's only a linguistic change.
No, not really. It would be an intent change.
No intention, there's no intention. May I also add in paragraph 6 of the proposed directions, I want to add one small thing at the end of that paragraph. Paragraph 6 ends like this: under all relevant laws, probably I would like to suggest, and to suggest provisions towards due compliance. You lords may kindly add that. In paragraph 6 at page 26, and to suggest provisions towards due compliance.
Provisions
For due compliance.
Because that will take the matter forward. Suggest provisions towards due compliance. And as far as 7 is concerned, there have been in-depth discussion on the shared liability victim compensation scheme. We had lengthy discussions with RBI, banks, and then DOT, etc. I think let us have a little more discussion on that. That's why feasibility. Once you know that there is a
Earlier part of the report indicate that at one point this issue was discussed.
correct.
But then probably, as she is rightly pointing out, there is no formal proposal made. So she wants that instead of feasibility, let there be a proposal put up before the interdepartmental committee.
No difficulty about that, but I thought there be some element of finality on the thought process between the different departments. If you so RBI says I have some reservations on that. That's why we use the word feasibility. I don't mind saying proposal. There's no difficulty at all. Ultimately,
Let it be proposal. Let it be.
there's no difficulty at all.
Where you want to engraft exceptions, you can.
No difficulty. Let us not waste our time on words. Yeah, no issues at all.
Rest of the directions are fine.
Very
Well, in terms of 8, my draft specifies a timeline, if possible, of 6 months, because expeditious still leaves it open-ended. So if
Forum is different.
true, it may be difficult. Therefore, I'm not pressing it, I'm just mentioning.
Forum has different types
Milady.
of loads and liabilities, right?
True.
Then time frame begins all other problems.
Yes, and I do not have any additions to the other proposals. There are only 2 aspects which are not covered here, which are in my draft, my lords. One is directions for Department of Telecommunications and for RBI, because all these suggestions take care of preventive and protective measures. And one, the shared liability aspect with respect to existing victims of digital arrest. My lords had indicated in several hearings that action should be taken against errant banking officials, point of sale agents, as well as TSPs, telecom service providers. Those aspects do not form part of either the status reports filed or of any discussion. IDC may be directed to also take up those aspects and submit on.
Have you mentioned in your note?
Yes,
Any expansion of RBI directive.
I'll point out.
My consulting RBI, because it may have
Manoj,
ramifications.
I have submitted a separate collation only of the directions for easy reference. If I may take that as a thing.
Like this, there is another volume. Make a set.
The directions, Manoj's very first set is for DOT. Even out of these, I'm not pressing for all of it. I'm only asking for this one
In
point.
fact, IDC is looking at this aspect in the second and the fourth report. Talk about it, but I think
Directions to the under the head of telecommunication.
Yes,
Which direction are?
the first one, very first one, DOT to submit an action taken report against errant TSPs, POS agents, which resulted in digital arrest scams in line with the observations of this honorable court. The same thing can be modified only to say DOT and RBI to submit action taken.
So we are including all your suggestions also in part of.
Miller.
in fact, I don't want to be at cross purposes. In the second and the fourth status report, we have played a lot of information about it. I'll just recapitulate. About 6,437 POs involved in suspicious selling of SIM cards have been blacklisted. And then 1,003 FIRs have been lodged, 16,006 POs have been so action being taken. I mean, progress is taking place. Therefore, we probably will give more report on the next information, the next report. So IDC is looking at all this.
This court has this previous orders dated 1st December 2025, 16 December 2025, and 9th February 2025. Interim directions to secure a coordinated response to the menace of digital arrest scams in India. Those directions concern inter alia investigation by CBI, mule accounts, for misuse of SIM cards and SIM boxes, from a cooperation by intermediaries, from a grievance redressal, from a restoration of defrauded money, and institutional coordination. Next paragraph. Plan Attorney General for India placed on record the fourth status report dated 3rd August 2026, filed by, as placed on record, filed by the Indian Cybercrime Coordination Center in bracket 14C. I4C, sorry, I4C.
I4C.
I4C from a Ministry of Home Affairs. The report incorporates the deliberations of the fourth and fifth meetings of the Interdepartmental Committee held on 11th May 2026 and 14th July 2026, and the action taken by the concerned ministries or regulators, investigating agencies, telecom service providers, and intermediaries. Next paragraph. The report primarily states that the number of complaints received on the National Cybercrime Reporting Portal pertaining to digital arrest scams have sharply declined from 1,23,672 in 2024 to 58,239 in 2025, and have been further reduced and stood at 16,377 for the period ending 30th June 2026. The corresponding reported defrauded amounts have also substantially reduced. While this trend is certainly encouraging, there is no gainsaying that continued monitoring remains indispensable.
That's true.
As per the fourth status report, Raputovo reports that the data sharing MOU between the Reserve Bank Innovation Hub and I4C was executed on 11th May 2026, and the grievance redressal mechanism portal now covers 1,23,590 branches of 69 banks. Additionally, the money restoration mechanism portal has 57 participating banks and all 36 states and union territories, with restoration completed in 36,290 cases for an aggregate amount of 18.05 crores. Next paragraph. We are informed that the E0 mechanism is operational in 19 states, while only 14 states have notified their state cybercrime coordination centers. Similarly, the telecommunications in bracket radio equipment possession authorization bracket close rules 2025 have been notified, while the telecommunications in bracket user identification bracket close rules 2025 are at the final stage of notification. Next paragraph. So far as investigation by the CBI is concerned, the report revealed that the investigating agency has presently registered 10 digital arrested cases and several related cases. In one investigation, it identified 238 victims from a 67 first layer bank accounts, transactions of approximately rupees 80 crore, and conducted searches at 93 locations around 16 states. It is further stated that the interdepartmental committee has requested the CBI to examine the feasibility of lowering the existing threshold of rupees 10 crores and also to consider taking up cases involving the same organized network where the cumulative fraud exceeds the prescribed threshold. Next paragraph. We have further heard Learned Attorney General, Ms. M.S. Napenai, Learned Amicus Curiae, and other counsels appearing for the parties and interveners. While the progress reported at this juncture is appreciable, at the same time the mechanisms already put in place require wide adoption, faster disposal, and continued follow-up. We accordingly deem it appropriate to issue the following interim directions. One, the RBI shall within 4 weeks formally adopt and circulate the standard operation procedure in bracket SOP describing the action to be taken by banks for placing temporary debit holds on amounts or accounts linked to money-mule activity and cyber-enabled fraud. A copy of the final SOP shall be furnished to High Court C and to the Registrar General of all High Courts. 2. The to all the states, UTs and law enforcement agencies are directed for expeditious adoption and operationalization of the 2 modules, namely 1I grievance redressal and money restoration modules under the MHA's SOP concerning NCRP-CFCF RMS and 2I custody and restoration of money and grievance redressal
Module.
dated 2nd January 2026. They shall also take steps for awareness of the 2 modules, public awareness of the 2 modules. Next, the Registrar General of all High Courts shall bring the grievance redressal mechanism to the notice of the courts and other adjudicating authorities dealing with freezing of bank accounts in cyber fraud cases. An aggrieved person may ordinarily be encouraged to avail that mechanism in the first instance, though it shall not be a bar to any constitutional, statutory, or other legal remedy. The next status report to be filed shall apprise us about the state-wise and bank-wise statement of grievances registered and disposed of, restoration order is issued, restoration is completed, and amounts restored. The remaining states, the remaining states and the union territories are directed to take steps to notify and operationalize their state cybercrime coordination centers within 4 weeks. They shall also take steps to adopt E0 FIR mechanism in consultation with I4C. The Ministry of Home Affairs shall provide the requisite assistance in this regard. Next paragraph. For expeditions, it is directed that for expeditious disposal of matters relating to freezing of bank accounts arising out of cyber-enabled financial frauds, यानी इसमें कवर हो जाएगा, कवर हो जाएगा. Then say the interdepartmental committee is directed to issue necessary directives, advisories, and instructions to all states, union territories, ministries, and government departments to undertake and promote awareness programs about cyber crimes, grievance redressal and money restoration modules, as well as custody and restoration of money and grievance redressal dated 2nd January 2026. Then say the interdepartmental committee is further directed to consult with the intermediaries and banks regarding the possible technological steps that may be undertaken to 1. Prevent digital arrests, 2. Assist in recovering the defrauded amount.
Then legal services authority to
Assist in the investigation of digital arrests.
It's important.
And 4. Cooperate and discharge their obligations under all relevant laws and provisions for due compliance of law. Next paragraph. We also deem it appropriate to direct all the state legal service authorities to immediately formulate schemes for public awareness on the issues of to prevent digital arrest, to make the people aware about the
cyber crimes,
digital arrest,
and awareness about cyber crime.
and awareness about cyber
Security.
Security,
Cyber crime, digital arrest, and awareness relating to cyber security.
as also for their assistance in the recovery of the defrauded amount. Next paragraph. The interdepartmental committee is directed to discuss the proposal of a shared liability and victim compensation framework. Next.
A time frame for submitting the same if possible.
A status report in this regard shall be submitted before the next date of hearing. Next, all adjudicating authorities, including RBI Ombudsman, Consumer Protection Fora, jurisdictional courts, and law enforcement agencies are directed to ensure that the amounts recovered are disbursed to the victim of digital arrest, to the victims of digital arrest in an expeditious manner. The status report for the progress taken into this act shall be filed before the next date of hearing.
You can have it, right.
Next paragraph.
Eighth September. 15th September. That's all right.
The Victim Compensation Subcommittee of the the CBI, while continuing its investigation in terms of the previous directions, directed to examine the suggestion given in the status report filed by Learned Attorney General for reduction of the present threshold or discount crore, the aggregation of cases involving the same organized network. A separate status report in this regard be filed. The proposal concerning a time-based inverted commas full switch inverted commas close for audio and video calls may be determined by the Ministry of Information Technology, the Department of Telecommunication, and I foresee, in consultation with the affected intermediary, and let a brief note on the technical feasibility, efficacy, safeguards, and alternatives be placed on record before the next date of hearing. Next, the interdepartmental committee shall continue to coordinate implementation of the above measures and consult intermediaries and banks and technological steps for prevention, recovery, and investigation. A fresh consolidated status report shall be filed in this regard with advance copy to Learned Amicus QA. Do we want to incorporate all your suggestions?
Well, if I may just make it shorter, my lords. The first one I was suggesting, my lords, is one is a common direction to DOT and RBI to submit on the action taken reports with respect to the banking officials, errant banking officials, TSPs and POS of both regulating entities, my lords. Just one, that will capture 3 or 4 of the suggestions that I have put. And the second thing is
Part
for,
of your direction.
my lords, in the very first one, my lords would get it.
I don't think there's need for any specific direction in this regard.
My lords, because otherwise no action.
No. IDC will look into all that and give all the information the court needs.
The very first one, which is for DOT, can be made for both DOT and RBI.
So Lordship, see the 4th report, this report, annexures R6, R7, R8, R9, they all utter the same question and we'll continue to update the information. I don't think there's a need because IDC is seizing of the matter.
The reason why I'm submitting this, is there are 2 aspects to existing ongoing cases. One is with respect to action to be taken against these errant officials. But there is also an issue of what is the liability that they will then meet with respect to the complicity in terms of the scams that have taken place, which they may have facilitated or been part of in some manner. That aspect has not been gone into at all, and therefore this direction is sought.
No, the direction again is very general. I said IDC is looking into all that And then once they have collected some data, you'll put it before the court. And in fact, in the second report on 9th of February, we have put in all that information that available at that point of time. The fourth report improves on that.
Wanting that some specific action taken report with respect.
Of course, of course. We don't need any specific direction. in it.
Providers
Doesn't
which are-
harm them if there is a direction.
The telecom service providers are also a big challenge.
That's why in direction 4, 5 and 6, that will be covered. You'll also already cover that issue. I mean, IDC, in fact, doing a good work. I've been meeting them at least 3-4 times, and they're taking it very seriously. We spend at least 2 to 3 hours every meeting.
But let telecommunication authorities file a separate status report, Mr. Chairman.
No, in fact, Annexure R12 of this report, fourth report, is a summary of all the action taken record against TSPs submitted with you. It is already there. We keep on updating it. That's all we need to do. IDC is aware of its work to be done in this regard.
No, but,
I'm not saying no, but then since you're already doing it, we don't need a repetition of a direction.
so what action have they taken against?
It's contained in all the annexures. For instance, Annexure R12, it gives you all the details of what action has been taken. So what I would suggest is let them continue to do this work and give an updated report for the next year.
Directed that they will continue, but question is that if they have identified some errors, if the service providers are not complying with the.
Certainly, IDC will come before the court and say they are not complying. That's why Direction 5 talks about consultation with them, ask them to comply with certain directives.
Let them file a status report.
We'll do that.
The Department of Telecommunication Directive. Submit an action taken report against the errant telecom service providers, POS agents. Let's cause the digital arrest scams. The status report shall also respond on the suggestion for a unified dashboard. SIM abuse, including through issuance of duplicate SIM cards or the misuse of know your customer, the bracket KYC, bracket processes for issuance of additional SIMs.
Let's with respect to RBI, the only direction that I'm seeking, my lords, at this juncture is they have already submitted that there are 2 research papers for the delayed transaction. That's the cooling off period which was submitted before my lords in the second hearing itself. Delayed transaction safeguard and lagged credit mechanism and customer protection in electronic banking transactions. Now, what the status report says is only about a research paper, but it will have to be action through a regulation. Therefore, that may be a direction to RBI. My lords would get it at page 3 of the collated directions. The very first one under RBI's.
Serial number?
Serial number 1 under RBI in page number 3. Learned amicus suggestions.
Delayed transaction safeguard.
No, at page 14 of
The very
the report. I'm sorry. Page 14 of the report, it talks about what RBI has already done.
That refers to 2 research papers.
Not
Research papers.
research papers alone. Can you
That's
see
a
that?
good beginning, but it will have to be time bound and implemented.
Page 14. Thereafter, at the end of page 14, Lordship can see after all that consultation. So they have to,
For research.
there is a public consultation, they have to examine it. I mean, they will certainly come forward. I don't think they need a prodding.
It's the direction for a time bound implementation.
The
Or a
RBI,
response
I'm so sorry.
to this honorable court in terms of what is the state. What happens
The RBI is already on the job. They're going to do that. We don't need a prodding for that purpose.
My lords, we are not looking at it as adversarial. This is just to ensure that the good work gets carried forward.
No, I wish you give a little time to RBI to do their job. They must do their job. They've gone for consultation, see that comments have come, and with the next IDC meeting, we'll take stock of it.
Seeing direct.
That's when they have to.
Manoj, may I make a simpler suggestion, Manoj? I have given a detailed submission. It may just be directed that IDC may consider all the suggestions or submissions by amicus and they may action it. Just a catch all, and I'll then leave it to IDC.
Consider all stakeholders with direct.
Manoj, as of today, Manoj, whatever has been submitted today,
To whom we should direct?
IDC may consider the submissions or suggestions.
Yeah.
Department committee consider directly to consider all the consolidated suggestions, or recommendations that have been made by the land provider.
Manoj.
Post the matter after 4 weeks.
Around maybe in middle of September. So it's been a little more time. Around the third week of September. I mean, IDC has to do a lot of work.
First or second week of September.
It will be the third week of Lordship. 22nd September, I think. Because what happens is after the IDC has a meeting, then it comes back to me and then I look.
What about 9th September?
No, we need a little more time.
10th September or
No, I thought either 19th or 22nd.
16th September.
Very well. Because what happens is I just want to share my
19th or 20th.
19th, is it? Very well.
19th is holiday. Then 16th September.
Very well. Very well. Just one small.
Item 17 is tagged with the tag again.
In direction number 6, one small suggestion. Lordships, in direction number 6 at page 26 regarding committee to consult, etc. I said, and to suggest provision towards due complaint. The word suggest may kindly be added so that it makes sense.
So what date? 19th is 16th. Okay.
Okay, accessible tomorrow?
Yes, Manoj. Please give us some time so that we can finish it. I understand, Manoj. If tomorrow, if your lordship can take it up, Manoj.
On priority, Manoj.
Whenever it's.
We are not aware about the code list tomorrow, but the miscellaneous matter will have to first.
No, I don't dispute, Manoj. Just give us some time tomorrow. That's all, Manoj. If your lordship fixes it at 2, Manoj, then we'll.
In any case, not before lunch, you come to.
All right, so 2 o'clock, Manoj, we'll be here, Manoj. Your lordship may take it up. That's all, if it's possible. Otherwise, Manoj, we always seem to be running out of luck.
With my lord's permission, may I please mention a matter, my lords? My lords, this matter was filed on Wednesday. However, the registry raised some objections. We have made our best efforts to clear it out. We just wanted to be listed urgently tomorrow, my lords. There's demolition notice has come and tomorrow 11 o'clock, I'm told that they'll come. If it could be taken up tomorrow. We have received the demolition notice today at 3:30, my lords.
3:30.
Today at 3:30 we have received.
No, but you didn't go to High Court.
We have already filed a petition here, my lords.
SLP.
SLP here, and it is pending. It's pending in the registry, my lords.
Dismissed the matter.
Yes.
Yes.
Special by the High Court, you have received a demolition notice.
Yes,
When was the order?
30th June.
30th of June, my lords.
30th of June, the order was passed. They were waiting for this.
You clear the defects.
I have done that, my lords. If only my lords could direct.
लगा दो कुल to Wednesday को जाके.
Your Honor. So grateful, my lords.
Your Honor, I also got the diary number kindly listed for day after tomorrow. I got the diary number kindly listed. for
मैडम
day-
आपका तो लगेगी पिटीशन, आपकी कौन मना कर रहा है?
Sir,
We'll list
please,
your petition day after,
slip is there day after tomorrow.
day after.
Janab, agar kuch, I can get something mentioning over there. sir. Day after tomorrow, but how to tell that to the registry?
Your summons is for next week, no?
Highly.
Well, as I mentioned, Your Lordship said to give a consolidated list, well, in one volume. We've done that. So, well, it will be easier for Your Lordship.
It will help you and us both.
We don't have to, well, move from one volume to another.
We'll take up tomorrow, maybe 2, maybe maximum 2:30.
Maybe.
Well-
That's fine, as long as some time is given.
Your junior will come before lunch, we get up at 1 o'clock, we will let you know.
Deeply,
So that
deeply.
may not wait.
Very well.
नमस्कार साथियों, स्वागत है आप सभी का हमारे इस लाइव सेशन में। आज हम एक बार फिर सीधे जुड़ रहे हैं भारत के सर्वोच्च न्यायालय माननीय सुप्रीम कोर्ट की लाइव कार्रवाई से। कोर्ट रूम में आज देश के कई गंभीर और महत्वपूर्ण मामलों पर सुनवाई हुई है। इस कार्यवाही के दौरान आपको देश के जाने माने वरिष्ठ अधिवक्ताओं के बीच बेहद शानदार और धारदार बहस सुनने को मिलेगी। कानून के दिग्गजों के तर्क और माननीय जजों के सवाल आपको बहुत कुछ नया सीखने का मौका देंगे। आपको बता दें कि हमारी यह लाइव स्ट्रीम पूरी तरह से केवल शैक्षणिक उद्देश्यों के लिए है। इसका मकसद देश के कानून, अदालती प्रक्रिया और वकीलों की दलीलों को आसान भाषा में समझना और समझाना है। तो कानून की इस बारीक समझ और लाइव अनुभव को जानने के लिए हमारे साथ बने रहिए। माननीय सुप्रीम कोर्ट की लाइव कार्रवाई अब शुरू होने जा रही है।
That's specifically listed for it to be listed on the 5th of August. It's not showing in the main list.
This is a language issue where the children are having that difficulty. They're stuck in the middle now.
Lordship, may I please make a mention?
On 20th August. That's why all matters are being.
The main case had been.
This is the main case.
Main case, my lords. This is the main case, my lords. This is the Yashika Bhandari case, my lords. If I may just present this, my lords, to your lordship. The entire batch was listed.
In fact, next week, I think there'll be a difficulty for the Solicitor General. Your Lordship remembers, he said he's leading some delegation of the UN. So next week may be difficult for them. It was slated for tomorrow, my lord.
20th is not week after next.